Madam,
Yes.
for a study made a mention for listing today, but for my son listing it is not listed. So may I pray marriage urgent also Miller. So may I pray it may be taken today at 2 p.m. Miller.
Bail petition,
No, Miller is criminal revision.
criminal revision,
My lord.
new matter,
New matter.
new matter.
My lord.
Okay.
May I please, your Lordship? Lordship, today I have filed one additional affidavit in connection with Lordship, item number 58, Lordship. Kindly that may be called for.
May I
APM,
be your
my lord.
Lordship? I have actually mentioned item number 57, my lord. Lordship, it will be taken now after vacation, my lord. My senior is out of station, my lord.
Just a minute. Case diary. Received.
Yes, my lord.
Are you on interim?
My lord.
You're on interim.
Yes.
So
Immediately after vacation.
there's no time also. John for the day and list on 5/1/2025. Case diary shall be retained or you'll send it back? 15 days. We can actually dispose it off also. Should we fix it tomorrow?
My lord, you can, this is out of station, my lord. This problem, my lord. Immediately after vacation, my lord.
5/1/2025, interim bail stands extended. Case diary be you send back and procured again. For the next date.
Item number 41, we have filed affidavit in opposition. That may be called for. Item number 41, 58.
39 and 40,
41 and 58. I am for the informant.
41 and 58.
I'm for the informant.
Okay.
May it please your Lordship. Lordship, I beg to mention item number 38, Lordship.
38.
In this case, I am on interim, Lordship,
Mhm.
but CD is not available, Lordship. 38.
Let them cross check. Not available.
Not available.
Case diary not received, issue reminder. Full stop. Interim
Lordship,
extended till the next date of listing. List on 8/1.
Lordship.
May I please,
Oblige your Lordship.
please, Your
Tell
Lordship,
me.
I beg to mention item number 30, Lordship. Kindly adjourn for the day, Lordship. 30.
Just diary. Three zero.
Received a case diary.
Receive the case diary. Interim is there.
It is there, Lordship.
So we have to retain it. Can you do it today or tomorrow or day after?
Possible, Lordship, my senior.
Yes, my lord. Every day has been called, my lord, and all the 80% APR, my lord.
Have appeared.
You can dispose of this matter.
Is
This is
it-
a long pending case, my lord. Interim was granted in the month of.
We'll do one thing. Don't worry. Let it come up. Then we'll take a call.
Another prayer for a listing of a regular bail application.
May it please, your Lordship? May it please, your Lordship? I beg to mention item number 39 and 40, tag matters, my lord. Lordship, CD call for has not been received and I am on interim, my lord.
CD is not received. You sure? No?
After vacation, my lord.
39 and 40, no CD.
No,
Issue reminder, interim extended after the vacation. 7/1.
May it please your Lordship. My Lord, item number 43.
Yes.
Perhaps CD is not there, Lordship.
Long time, This is, I think, last date also there was no CD.
Last date, so the CD was there, but sent back for update.
For updation.
Yes.
After vacation. 7/1. Case diary is not received. After it was sent back for updation and was to be procured today. Full stop. The case diary shall be procured on the next date. Full stop. Interim bail stands extended till the next date of listing. Is the matter.
Take it up on 9, Lordship. 9.
Just before the last day, how about 8? Let it be on 8.
Lordship.
There's no particular difficulty.
Lordship.
8/1.
May I please, your Lordship? Lordship, last time your Lordship was fixed a date for tomorrow, but unfortunately, my Lordship in the order could be reflected 18th of January, which is Sunday. On that basis, my Lordship matter is not fixed for tomorrow, my Lordship.
It can be, yeah. You
Yeah.
made a mention.
Yeah, mention I have. Lordship, one more thing, the Lordship, I have a specific instruction. In the meantime, my Lordship, charge sheet is filed. So, my Lordship, can it be in the first week of January? In the meantime, I might be allowed to file the additional affidavit with charge sheet, my Lordship.
Okay, no, should it, you want it to be listed tomorrow?
Tomorrow, then again it will be, I have to call for the trial court report, seek for the trial court report, your Lordship.
It was by mistakes fixed on 18-1.
January.
Actually, it should have been 18-12. right?
Yes, my.
Let it come tomorrow and
Yes,
we'll
definitely.
take a pass on order.
Deeply obliged.
Okay. Let it come tomorrow.
May please, your lordship. I beg to mention item number 41, my lord.
Yes.
There is some difficulty on the part of my senior, my lord.
Today?
41. CD is there.
I am appearing,
It may be written.
For the informant.
yes, your lordship. So I have objection. I have filed affidavit in opposition, my
That
lord.
will be brought on record. Okay, let us do it before vacation. Possible.
My lord, after vacation, any day, my lord.
But the case diary is there, my lord. That's the difficulty.
No, that is
And
true
they are on interim. On
That-
on the
that's
last, on
That's
the-
true of all the situations where case diary is there and interim also there because we have the vacation in between, but we
They
also
are-
have less flexibility, only 2 days.
on the
right.
last occasion also date was taken and the CD was.
If possible, do it tomorrow or day after. If not possible, then on 5 or 6.
My
We'll
lord.
have to fix.
I was.
Return the case diary. And help
Then
it. In the mean-
hear me on objection. If that's,
Today.
yes,
My lord, there is some difficulty on the part of the leading council, my lord.
Can we fix it day after tomorrow?
My lord, yes, my senior has instructed me to, he is not available, my lord. That's why.
Not available today. No? I don't know. No, I will not force you. But the thing is that if it can be done, since he has filed an objection, if we can fix it, are you aware whether he is available on Friday? Your senior?
He
Or-
won't be available, my lord. After vacation, my lord.
What do you do?
Anything, my lord. After
I-
vacation, and then immediately after vacation.
Five-
my lord.
5-1. 5-1. In the meantime, at least bring your opposition on
CD
record.
would be retained then.
CD can be written, but it will hamper. It'll be investigation.
Well, let CD be retained, my lord. It won't be.
You want to retain the CD?
15 days or 15 days time will be sent by the investigation will take time.
Yes. Send it back. Same order. Yeah, please get it back on 5th.
My lord, interim may be continued, my lord.
Interim shall be continued. Actually, if there is interim, generally speaking, the adjournment should not be taken, in my humble opinion. At least for a long period.
My lord.
But anyway, because it hampers. Okay,
Yes, my lord.
on 5-1, 5-1.
My pleasure, Your Lordship. I beg to mention item number 33, Your Lordship. I think CD not received, Your Lordship. We are on interim, Your Lordship. After vacation, Your Lordship, any date. 30.
Case diary is not received, issue remains. Huh?
Oh, sufficient.
We'll take it up. At the time, let it come up.
That is a lot.
Yes,
I'd like to mention for supplementary list 59 and 60.
59 and 60.
60.
After
vacation,
they're connected matters.
connected matters.
After vacation.
59 and 60.
59 and 60. After the vacation, you can fix a date. After BU will do, after BU, fix it on 21. 21-1.
Much.
Motion be item number 1.
This is a second bail application. Previous
Yes,
rejection order is page 51.
no issues.
With the under trial case, 3 witnesses have been examined
That's good.
and further investigation is also ordered by this thing. Paragraph 12 onwards, Lordship.
Scan record has to be called again or it should be available, I think, or up to date scan.
New ground, one of the new ground is also ground of arrest.
But since it is a POXO case, my lord, notice is to go first.
Let the know, that's okay. Otherwise, will it be available here?
If it
Record.
is available, my lord,
That is-
it is to verify, my lord.
Hmm.
But my
There
lord,
is-
then up to that status report will be required, my lord.
There is no progress in the case, Lordship,
Hmm.
because
Same.
due to further investigation, trial is stalled. And today is also date fixed for
Further investigation need not stall trial.
trial is stalled.
They can continue.
Trial is stalled, Lordship. I have enacted some order sheet. Last order sheet was 6/11/2025.
The heard, so it is fairly submitted that this subsequent bail application, it's an earlier bail application was rejected by the order dated
30/10.
30/10/2025, passed in BA side of dot. Uh, The learned counsel submits that one of the new grounds is with regard to the statutory notices at the time of arrest. Nevertheless, it is also submitted that there is no progress in the trial. The steps of notice upon the respondent to informant shall be taken to the office of the public prosecutor and to be executed through the concerned police station. The registry shall also verify as to whether the scanned case record which was procured earlier is still available. Up to date status report will be necessary.
It will be necessary, my lord, to know about the status of the case.
An up to date status report regarding the trial, up to date status report shall may also be called from the learned trial court, that is the court of the learned additional session judge come special judge POXO, Silchar, Kasar Silchar,
Lordship, status of the further investigation may be given.
including the status of further investigation, if any. The special POXO case number 57 of 2025 corresponding to Silchar PS case number 502 of 25. GR 872 of 25. Complete information. List the matter on suggested date
19/1.
19/1.
Item number 2.
Obliged.
The regular bail execution, my lord. 157 days, my lord, and the
In the PS case,
lordship, commercial quantity involved, my lord.
investigation is completed. Or investigation is going on. It is at the stage of
My
investigation.
lord,
Okay, let us get the case diary then, right?
immediately after the case.
Mr. You, Mr.
M. Ali.
M. Ali, Learned Counsel, and R. Bora, Ajay Bora. The three petitioners hearing seeking regular bail in connection with Lakhimpur PS case number 80 of 25. They were arrested on 13/7/2025. And who were arrested on 13/7?
1 and 2 arrested on 13/7.
Petitioner number 1 and 2 were arrested on 13/7/25, and petitioner number 3
Three.
was arrested on 24/7/25. Call for the case diary. Full stop.
Along with FSL report, my lord.
Along with FSL report if available. List the matter on
8/1.
My lord, can it be earlier, my lord?
8/1 this one. Are you happy earlier?
3rd of January, my lord. if
That was
possible.
closed. It's not reopening. It's opening on 4th.
4th.
Site রেখে বন্ধ হবে, my lord, কিছু।
It's okay.
Item number 3.
Obliged.
কেটে কেটে আসি বলি। তারিখে রেখে। 8/1.
8.
Item number 3.
Arrest bail, my lord. FIR, my lord, you'll find at page 9. Allegations, my lord, offenses under my lord, attempted to murder and UVS heart, my lord. I had the occasion to go through this FIR earlier also, my lord, and granted bail to the other accused persons, my lord. That order, my lord, you'll find at 18, my lord. And the bail was granted considering the length of detention, my lord. At that time, my lord, those accused persons were 34 days, my lord, and today it is the 49th day for this petition.
Item number 3. 12 Islam. The petition number copy in it. 17 of July.
No, no, it will delay, right?
Below. কিন্তু পাহাড়ও দিছিলাম কিন্তু বলছিলাম পিএসকে
Salah PS case. He was arrested on 6/11
6/11.
on the same day.
Same day. Same forwarding report, my lord. Forwarding report, my lord will find, my lord. Page 17, my lord. Same day arrested. He's 50 years, my lord. The earlier accused were 34 and 22, my lord.
Forwarding is which page?
17, my lord.
17.
It starts from 16.
Oh, shit. That's it. Three were arrested, right?
3 persons were arrested, my lord. Accused number 2 and 3 have been granted bail. Accused number 1 before your lordship now, my lord.
Yes, tell me.
I tried to call for a case that on this station.
My lord will kindly see that those accused persons were released, my lord, considering the length of detention, my lord. I was given 34 days of detention. I'm not 249 days of detention.
Okay, they are on similar footing. I heard them and RJ Bora. I'll record your submission. Invoking 483, the petitioner so-and-so is seeking bail in connection with Patsala PS case number 94 of 25 under so-and-so section. He was arrested on 6/11/25. Full stop. Oh, it will have a lower. Am I order? Allegations now. 212, learned counsel submits that that 3 accused persons were arrested on the same day and forwarded. And out of them, 2 were granted bail by this court on 2/12/2025 in DA 3698 of 2025. Para 4. Para 4. I have perused the said order and para 6 thereof may be reproduced herein below. Let's stop. I find that present petitioner is also is similarly placed as the other 2 persons who have been granted bail. According, the present petitioner so-and-so is also allowed to go on bail of rupees. It's same condition. Same condition. Bail petition stands allowed and disposed.
Deeply obliged.
So learned additional PP 6 praise for calling the case diary at this.
But application is allowed, my lord.
Allowed and disposed of.
I'm deeply obliged.
May I please your lordship? The second application, the earlier the report was rejected, madam. And my lord, he was arrested on 3/11/2025. Today is 45 days, madam. My lord, 60 days is the statutory period, madam. The FIR is page 10, madam. FIR, my lord, lodged by Lat Mondal, and he's saying that the present petitioner representing himself that he is a chief minister vigilance.
Yes, I remember.
And
It was rejected on with a regular bail, right?
112.
112.
Yes, sir. Length of detention may be considered, madam.
Arrested on, he was arrested on which day?
3/11, madam. 45 days today, madam.
Yes.
And
told me.
except, my lord, one section and other 2 is valuable, madam. There 308
Yes.
is the only extortion, but sitting is the valuable, madam, and 351 also valuable, madam. Earlier rejected, madam, considering the materials on record, madam.
Yes.
Now this is the subsequent appeal application, madam. On new ground, it on paragraph 14 is a new ground.
Paragraph 14. Regarding length of detention.
Yes, ma'am. Maybe consider, my lord, because the informant also not in clean hand, my lord. Because I cannot argue now because on merit earlier honorable court rejected. He
Okay.
suppressed the facts. He already paid the 50,000. And the money was, my lord, only for landed money, my lord. But in the FIR, he stated that he only demand.
So, what updated case diary you want to get?
But it will be strictly over, my lord. Because reopen the opening, honorable court, my
That
lord.
will be one of the aspect, my lord. Otherwise, we can fix it day after tomorrow, but my lord, CD may not.
If ever it comes, CM vigilance,
Magistrate tribunal case, my lord.
CM,
Not session tribunal.
take a chance. Fix it
Day after.
day after tomorrow. We'll stop, Enuddin, learned committees. Fairly submitted that earlier bail petition was rejected on 1/12/25, passed in BA 3755 of 2025. Full stop. By way of new grounds, the learned council submits that that the petitioner has completed 45 days in detention vis-a-vis the statutory period of 60 days. Stop. And submits that there is also the intervening vacation. Nevertheless, call for the case diary, updated case diary from the concerned police station. List on 19. You take a chance. 19.
Ambulance.
Difficult to give interim also in these matters. Anyway, so try to get it. You are representing now. So you try to get it, huh?
May please, your lordship. But this is the second bail application, my lord.
Mm.
Earlier it was rejected, my lord. At this stage, my lord, we have taken two new grounds, my lord. But at this stage, my lord, I frame, my lord, that case diary may be called for fixing in the first week, my lord.
Fair enough. Stop. Submitted that the subsequent bail application as an earlier bail petition was rejected on 8/12/25 in BA 3800 of 25. Call for the updated case diary. Fix on, we can fix it on 8, oh yes, 8/1.
Deeply obliged, my lord.
Item number 6. Item number 7.
May I please, my lord? When pair for peers bail application, my lord, this is a case, my lord, the counter blast FIR, my lord. Now, my lord, this petitioner is a small scale, the shopkeeper, my lord. The petitioner is carrying on business, my lord, the meat shop owner, my lord. Can you see this FIR, my lord? FIR is page number 13, my lord. Page 13, this translate copy of the FIR. May I read, my lord? With due respect, I would like to inform you that on 1/11/2025 at night, so time in front of our house, my husband is Santosh Barayan, meat shopkeeper, namely Ananda Khanikar, and a small quarrel. Suddenly, I heard the Ananda Khanikar assaulted my husband on his head with a dao used for cutting meat. When I tried restraining the quarrel, he used abusive language and also threatened me later. Our family member, took my husband in primary health center at Amguri. He was referred to better treatment. So we went to Jorhat Medical College Hospital. This is the FIR, my lord. Can you see, my lord? This place of occurrence on dated 1/11. Can you draw attention, my lord? This date 1/11/2025, my lord. But FIR lost, the informant FIR lost lordship the 6/11/2025 of 25, my lord.
Okay.
After 7 days losing the FIR, my lord. Any lordship incident may be happened, my lord, after gappings of the 7 days, my lord. And now, my lord, I have lost I have completely lost the superintendent, page 20, lordship. The superintendent of the police officer, the Sibsagar, my lord. The before, my lord, 10/11/2015, my lord. But my case is still going on, my lord.
Why your wife had lost this?
Yes, my lord. Now
On
we'll
11.
go for it.
I'll read it. I just go
Yes,
through it
yes,
once.
yes.
I'll go through it.
Okay.
19. I have to turning home. Santospur.
One on each.
This case was not registered,
Yes, my lord.
not
It is-
registered.
It is not registered, my lord.
Then
It
how-
is complaint, my lord.
It's
The
later
report
in point
filing.
of time.
Then now, my lord, may I request, my lord, at this stage, my lord, 118 subsection 2, this is the.
Give you a cert.
Yes, give you cert. But as per FIR, my lord, as per FIR reading, my lord, there is no mens rea, lordship. It's totally absent, my lord. Say intent or knowledge, my lord. It's totally absent, my lord, mens rea, my lord. And we cooperate same blazer. Both informant and accused are in same blazer. Can you see this?
No, but assaulting with a down on the head.
No, my
Part of the
lord.
body.
But the counter
At
story is weak because it is, the FIR is later in point of time and it is not registered also.
Yes, no, kindly, this, my lord, this FIR lost superintendent of police, my lord. Just forwarding report, maybe I think it's a complaint. Then after lodging this FIR, my lord. And main point is, lordship, the 7 days delay explain. This FIR cannot explain, lordship, the delay reason, my lord. 1/11/2025, my lord. Place of occurrence dated, my lord. And next, my lord, FIR lost 6/11/2025, my lord.
Is there any,
Then-
in the,
on that ground,
in the original FIR, is there any explanation for the delay of 5 days?
No, my lord.
It's an incident took place on 1/11/2025, 7:15 PM in the night, my lord. Thereafter, my lord, the victim was taken to Aburi
Hospital.
Hospital, my lord. Thereafter, he was shifted to
Treatment,
Durad Sumir Hospital, my lord.
That is why.
But there is no explanation in the FIR, my lord, why there has been delay, my lord.
Mhm.
But that delay is not settled, my lord, at this point of time, my lord.
And may I request, my lord, at least.
So this is not a
at least, my lord,
classification, my lord.
Yes,
It's a
that
bail
is-
application, my lord. And whether their prima facie material is there or that has to be.
At this stage, my lord, the medico legal certificate, my lord, at this stage, it will comes, my lord. Then interim may be protected, we cooperate investigation. Any materials against me, then my interim may be vacated, my lord.
That is why I've said, no, whenever interim is given in serious cases, for some reason, the bail petition should not remain pending. We
Right.
should adjudicate it,
My lord.
you know, because this is just a preliminary view and the circumstances may not justify later on. Anyway, heard so and so. Invoking 482, the petitioner Lakhi Khanikar alias so and so is seeking anticipatory bail in connection with Amguri PS case number 22 of 25 in the so and so section. One Devi Rani Bora, wife of Santosh Bora, lodged an FIR dated 6/11/25 against him with the allegation that on 1/11/2025, her husband and the petitioner, who is a meat shopkeeper, had a small quarrel, and thereafter she heard him assaulting her husband on his head with a dowel used for cutting meat. Semicolon, that comma, her husband was later hospitalized. The learned counsel submits that there's no explanation in the Ezdahar about few days delay in lodging the same. This also submitted that with regard to an incident on 1/11/2025 at about 9:15 PM. His wife had also lodged an FIR on the informant's husband through the superintendent of police, but due to the apology of Santosh Bora, they did not proceed further. No case was also registered with regard to the same. Call for the case diary along with medical report. Allowing the prayer of the petitioner's prayer in this regard, it is directed that in the interim, in the event of his arrest, 25,000 at once. Corporate investigation appear before, not harm the informant slash victim, informant and victim in any manner. You can fix it after view 21.
21, my lord.
21
201.
or 201. 201.
Deeply obliged, my lord.
Supplementary 55.
May I please listen? My lord, this is clear as bail application, my lord. My lord, we are not FIR name declared, my lord, only two more FIR name
accused persons granted interim bail, my lord. Case number 15, my lord. My lord, we are driver by profession, my lord.
Thirteen, 12.
My lord.
What happened to this?
My lord,
petition?
yesterday the matter was listed again fixed on 19-1, my lord. CD not received, my lord. So, my lord, we may be protected, my lord, and fix the matter on.
See, this was, there were serious allegations in this matter, Mr. Borua. There were serious allegations in this matter. So we on certain grounds, we gave interim, but the CD, got delayed and it got extended. So two things have to be, once interim is given, the CD must come on time and bail petition must be disposed of unless there are some other intervening factors. Anyway, he is not named in the FIR.
No, my lord. We are not FIR.
Raju Lali Ajibu. And ultimately, the investigation gets, this thing, because they cannot be examined also.
My lord.
Anyway,
My lord, one Nova Mohanta, Porosmani Das, and Manoj Chaudhary FIR. And Deepankar Chaudhary.
লিখি দিব ইয়াৰ পৰা লৈ লওঁ আগৰটো Mr. Pramanik, the learned counsel submits that two petitioners, two FIR accused persons, namely Nava Mohanta and Parashmani Das, were granted interim protection on their pre-arrest bail application by the order dated 10/12/2025 in AB 2910/2025. Para 5 to allegations. It is submitted that the present two petitioners are not FIR named also. It was the FIR once again. Any submission from your side, Mr. Borua? Any submission?
Let the case there be called for, my lord, with the allegation bearing the FIR.
They are not named, so others have been named. Names have been given. Stop. Okay, same move. Allowing the prayer in this regard. Call for the case diary and this fixed on. This must have been fixed on another date. 16/12.
16 was already gone, my lord. Let this letter be come up, my lord. Ending with AB number 2910, my lord. My page number 14, my lord.
Yes, 2910. Now, do you know when 2910 has been fixed?
But that have to verify, my lord.
19-1, my lord.
19?
19-1.
19-1, my lord.
Yesterday I have verified.
Last day, let's take a chance if it comes, otherwise after that.
19-1, 19-1, my
Oh,
lord.
19/1.
19 January.
Interim on same grounds, same terms. And they will appear, record their statements. 19/1/2025. Along with AB number, it will.
2910, my lord.
Yes.
2910.
Yes. No problem.
Bail hearing be at 12.
Highly obliged.
Item number 12. Bail hearing be at 12.
Oh. Goodbye.
Lordship, this PRR bail application case there was called for, Lordship. Lordship will find the FIR at page 9, Lordship. Number 1 is the father-in-law, who is the husband and 3 mother-in-law, Lordship.
Zakir Hussain is brother-in-law,
Father-in-law.
father-in-law.
But the specific allegation is against the petitioner number 1, Lordship. Son,
Petition number 1.
Zakir Hussain.
What is the allegation? Like your father-in-law. Teacher. Bad allegations, right?
Bad relation, but just not ready to continue with the conjugal life, Lordship. And
Anyway, let us get the, get the case diary. The second part implicates them also.
182 statements
Bit.
implicated.
Hmm?
And
Case diary has been
yes,
received.
bail hearing.
Oh,
There may be independent witnesses, Lordship, if any.
then it may not be justified if an anticipatory bail.
But-
Anyway,
183 statements implicated and 180 statement also is consistent with 183 also.
he has implicated what about the mother-in-law and husband?
Only because of only against this, his father-in-law.
Yes, no, I mean, against mother-in-law in the FIR, they said that when they,
All the members have been given electric shock, that is the statement, all the members.
that is a
Not
serious.
specific
offense,
allegation
correct.
against the mother.
Beaten up badly.
Yes, got it.
Can I have a look? if
Yes.
possible? Yes, tell me.
I may not rest for one Lordship, 2 and 3 may be Lordship.
Yeah, I understand.
Lordship.
That's a reasonable prayer.
Lordship, one next one.
Hmm?
Lose space, Lordship.
Yes, yes.
Funding 182 statement, Lordship. Please consider with that. No specific allegation against the tree.
Hmm?
No specific allegation against the, is a number 3 Lordship. But other
No,
two fully implicated.
No, they're saying that all of them.
Yes, given
electric
electric
shocks.
All members.
All that is the, of course, the main allegation is against the petitioner, but heard. 482, invoking section 482 BNSS, the 3 petitioners herein, namely so and so, are seeking pre-arrest bail in connection with Nagaon PS case number so and so. In the FIR dated 9/10/2025, the informant, who is also the victim, has alleged that taking advantage of the fact that her husband, within bracket petitioner number 2, worked in a private school and used to come late, comma. Her father-in-law, within bracket petitioner number 1, used to have illicit relationship with her and also gave her tablets, whereupon she became semi-unconscious, and that he did such illicit acts on more than one occasion. It is further alleged that when she informed about it to her husband, and thereafter inform and threatened to inform it to her father, the accused persons tied her up and gave electric shocks, and that later she could somehow manage to escape from the house. The case diary has been received. The learned petitioner counsel submits that the court can, that perhaps the anticipatory bail may be considered for petitioner number 2 and 3. If at least 2 and 3 at least. The case diary is perused. The learned additional PP, Mr. Goswami, submits that in the statements of the alleged victim have been recorded during investigation, and our statements before police and learned judicial magistrate are consistent, and has seriously implicated not only the her petition, her father-in-law. Full stop. She has also supported our allegations with regard to petitioner number 2 and 3 about being tied up and given electric shocks when she wanted to reveal the matter of the illicit relationship to her father. In view of the immersed facts and circumstances, it may not be a appropriate case for grant of anticipatory bail. Accordingly, the petition stands rejected, return back the case that. Loose sheets, huh? 164 loose sheet. Has to be returned, loose sheet. There's a copy. Loose.
13.
Service is completed in this case.
POCSO matter.
May I please, Lordship?
Yes, tell me.
Lordship, this is POCSO, Lordship,
Yes, yes.
trying for granting bail, Lordship, who has been judicial custodian since 28/5.
Yes.
Letter of POCSO
service is completed, Lordship, amicus may be appointed.
Yes, yes. Informant service is complete, so we can appoint an amicus. It is submitted by the learned additional PP that service is complete upon the informant. Since none has appeared, learned counsel. This call is this call definitely. Manisha MK Brown. Learned counsel is appointed as amicus. You kindly serve a copy to her, huh? Learned petitioner counsel shall serve a copy to the amicus. Scan record has been received. We can take it up tomorrow. Tomorrow?
Lordship.
Yes. The accused is in custody since 28/5/2025. You serve the copy, we'll take it up tomorrow.
Highly obliged, Lordship.
Yeah, take it in there.
Mm-hmm. 14.
May I please, Your Lordship, before you take bail application, Your Lordship, the sessions case number 23 of 2025, before district and session judge Majuli, Your Lordship.
Lordship,
the actual fact of the case is that the
7.
said, Your Lordship, the Latubara illegally trespassed the boundaries of the accused, Your Lordship, and then entered into the house of the accused and angrily asked the accused husband and son about the whereabouts of the accused. And then they informed the Latubara that accused is cooking in the kitchen, and then he dashed forward towards kitchen and get hold of the hair of the accused and forcefully dragged her, Your Lordship. And at the moment, as the accused was in a cooking condition and was about to fall down, the spatula which was in the hand of the accused got hit in the eye of Latubara accidentally, and then the son of the accused came to rescue her. And the said Latubara, in a haphazard condition, tried to flee away from there, and while doing so, the said Latubara got hit in the right eye, Your Lordship, by a kami of bamboo bear, Your Lordship. Sustained cut injury in his right eye, Your Lordship.
Ladle, what is ladle? What is ladle? What
Your
is
Lordship.
this thing which he hit? According to the
cooking-
allegations, he
cooking
hit.
thing, Your Lordship. Your Lordship, the
Prosecuted case.
yes, Your Lordship.
He lost an eye, I think.
Yes.
He lost an eye.
Your Lordship, charges submitted on 29/8/25.
Your Lordship, 131 days in the
Under section
police
29
under
1091,
Your Lordship,
112,
45 years old lady. Your
Terrible,
Lordship.
huh? He lost his eye because of the hit. He
Your
applied a
Lordship, the
heta,
victim himself
trying to
went to the house of Your Lordship, the accused, Your Lordship.
striking him in his eyes. No, the injury was caused on the eye by the heta. Heta, what is this? It's like a spade.
Kitchen thing, Your Lordship.
Mm.
As per medical report, the boy had a serious right eye injury from a sharp object,
Mhm.
damaging multiple layers of the eye.
Mm.
Your Lordship,
Surgery, corneal suturing, and removal of prolapsed tissues
Mm.
was done. So yes,
He lost an eye.
Lost an eye. There are 13 PWs are there. Charge framed on 23/9/25.
Only because of this factor, otherwise long
Three
period,
PWs.
she's
will
a woman,
examine.
long period, these are there.
She's
These are there.
suffering from
These are there, otherwise.
type
only-
2 diabetes, varicose.
Anyway, so has he been examined, victim?
Yes, implicated fully.
No, no, victim has been
Victim
examined.
examined. 3 PWs examined out of 13.
45
lost
years
his-
old
yes.
lady, Your Lordship. No chance of hampering or tempering the evidence, Your Lordship.
Only thing is that he has fully lost the life.
Her leg is in a decomposition. Leg would get decomposed, Your Lordship. The left leg, Your Lordship. Her, yes, Your Lordship. She's suffering from type 2 diabetes with varicose veins, Your Lordship, in his left leg.
Where,
Your Lordship, we have not filed the affidavit, Your Lordship, for the
medical document.
medical documents,
But,
because
you-
some of the medical
You
documents.
might have,
are in a
you must have stated somewhere in the paragraph.
Yes, Your
Have you
Lordship.
stated?
In page number 5, paragraph number 7, Your Lordship.
Good.
Point number 7, sorry, sir. Because some of the documents have been in a Xerox condition as it has been taken by the jail authority, Your Lordship. Marginally, Your Lordship.
Heard so and so. Invoking 483 VNSS, the petitioner. He can be given some interim victim compensation perhaps. Somebody is appearing for the informant side, no.
No, only the
From DLSA, if he's a poor person. Anyway. The petitioner is seeking regular bail in connection with Majuli PS case number 19 of 25, which after completion of investigation was charge sheeted and thereafter proceeding at present as Sessions case number 23 of 2025. And it is stated that so 3 PWs have been examined. Right?
Yes, Your
3 PWs have been examined. Scan record has been received. Amongst the allegations, the serious part is that with a Heta, during a quarrel, the petitioner caused an injury on the right eye of the informants.
Your Lordship.
Informants.
Informant is the sister of the victim, Your Lordship.
The informant's brother. Good stuff. After perusing the other documents, including the charge sheet, it is revealed that the said victim apparently lost his right eye due to such injury. The petitioner was arrested on 7/8/2025. Should have. It is stated in para 7 of the bail petition that being a patient of type 2 diabetes is suffering from varicose veins and there is degradation of her leg and which requires treatment, failing which there may be a risk of amputation. The nature of the allegations regarding the injury are undoubtedly quite serious, leading to the loss of eyesight of the victim. Nevertheless, balancing the various facts and circumstances and also keeping in mind the summation of the prosecution that the victim has also been examined, I'm of the considered view that the petitioner can be granted bail at this stage, subject to suitable conditions. Number 1. Or you give it basically 40,000 with 1 security of the like amount. 40,000 with 1 security of the like amount, subject to the following conditions. It will be available for the remaining trial. not hamper or tamper with evidence. She shall not in any manner cause any harm, harassment, or uh, to the informant, the victim, and their family members. She shall not try to influence witnesses. Violation of bail conditions shall entail cancellation of bail. The bail petition stands allowed and disposed of.
58,
Much obliged.
May it please, Your Honor. In this case, petitioner is shown as arrested. The main case, my lord, he has been granted bail, my lord. The FIR, Lordship will find as vernacular FIR at page 13, my lord. Earlier time, my lord, petitioner was under influence of alcohol, my lord. And my lord, in the other affair, my lord, that is mentioned by the police, my lord, I have placed before Lordship, my lord.
This
he
is
puts-
another case, right?
It is another case. This is, in this case, he is shown as arrested.
Much.
In the original case, my lord,
Right.
he is released on bail, my lord.
Hmm.
As far as that page 14, admittedly, my lord, he pushed the, my lord, victim, my lord, he fell down in the ground. Injury was there, my lord. Case is received.
Is there receipt?
No, itu bandas. Open na ho problem.
What is the allegation? Can we read the vernacular?
Vernacular. সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 18/11/2025 তাৰিখে সন্ধিয়া প্ৰায় 5:20 মান বজাত মোৰ ভাইটি সুৰজিৎ শৰ্মাই বাবা ওৰফে বাবা উত্তৰ লখিমপুৰ 7 নং ৱাৰ্ডত বজাৰ কৰি থকা অৱস্থাত উক্ত অপৰপক্ষগণে হাতত কিবা অস্ত্ৰ লৈ প্ৰাণে মৰাৰ উদ্দেশ্যি মোৰ ভাইটিক পিছফালৰ পৰা মূৰত মাৰি দিয়ে, যাৰ ফলত ভাইটিয়ে অচেতন হৈ মাটিত ঢলি পৰে। ভাইটিৰ মূৰত গুৰুতৰ জখম হোৱা হেতুকে স্থানীয় লোকে ততাতৈয়াকৈ চিকিৎসালয়লৈ নিয়াৰ ব্যৱস্থা কৰে। উক্ত অপৰপক্ষগণে পলাবলৈ লওঁতে স্থানীয় ৰাইজে কৰায়ত্ব কৰে আৰু পাছত আৰক্ষীৰ হাতত চমজাই দিয়ে। ইয়াৰ আগতেও তেওঁ মোৰ ভাইটিক প্ৰাণে মৰা ভাবুকি দিয়ে। গতিকে মহোদয়ে এই মানৱৰূপী দানৱৰ ওপৰত আইনগত ব্যৱস্থা লোৱাৰ বাবে প্ৰাৰ্থনা জনাইছোঁ।
As per injury report, Lordship.
You made a good translation. It's a correct translation. Humanoid monster. Correct translation. Translate correctly. What else can you say? Anyway, it's not easy to translate some terms.
My lord.
Mm.
This is why I am reading the vernacular.
No, it's okay. No. Yeah. What is the investigation?
As
says?
per the injury report, Lordship, injury was grievous, Lordship, by weapon, blunt weapon. Restoration of our left temporary parietal region, 2 into 1 into 1 centimeter cube. And witnesses also implicated and victim also implicated, Lordship. Eyewitnesses there, Lordship.
Actually, in the original case, he was arrested on 1911, my lord. Now 29 days, my lord.
The investigation progress for some time. maybe.
Progress, my lord.
Maybe.
Progress.
No, maybe. No, because allegations are also serious. Injuries are also serious.
Yes.
Hmm?
Injury is also grievous,
For some more time, maybe. Otherwise, have a look. Some
Lordship.
hard ones. 483 bail application. So whereby the petitioner Amulya Sakya is seeking regular bail in connection with North Lakhimpur PS case number 394 of 25, in which he was shown arrested on 27/11/2025. The allegation in the FIR lodged by the sister of the victim, Surjit Sharma, within bracket Baba, with the allegation that on 18/11/25 at 5:20 PM, the petitioner accused suddenly attacked her brother from behind with intention to kill, as a result of which he sustained serious head injuries, and that after the incident, The accused fled away from that place but was apprehended by the local people. Full stop. It is alleged that prior to the incident also, the petitioner had threatened to kill her brother. The case diary is received. Peruse the medical report. The medical report indicates injuries on the right side, injuries on the head, including fracture on left mandible bone. Full stop. The injury has been labeled as previous and caused by a blunt weapon. Full stop. It is submitted by learned additional CP that the victim as well as other witnesses have implicated. Considering these circumstances and materials, and also that investigation is in progress, perhaps it would be better to deny bail at this stage. Stop. Accordingly, the bail petition stands rejected at this stage. Return back the case diary.
Valuable.
Yes, you want it back, this one? You can take it back.
My pleasure. This is the charge sheeted case, Your Lordship. The petition was arrested on 23rd June, Your Lordship. Total custody 5 months, 24 days.
June.
FIR is page number 8, Your Lordship. It's a husband-wife quarrel, Your Lordship. Relevant portion is page number 12.
Scan record.
Injury is simple, Your Lordship. 5 months, 24 days.
Just
in custody. FIR is page number 12.
Yes. 8.
Incident 29/4. FIR loss on 5/6, Your Lordship. 37 days delay, Your Lordship.
37 days. 29 for hours. I see. Carries come?
PCR.
Have you seen the medical
Yes.
report?
Yes, medical report is a simple respiratory injury done by sharp object.
There was an assault, that means.
But 5 months.
Why are they fighting like this? Husband and wife, they are
Husband-
estranged or separated or something.
No, adjacent house, Your Lordship, and we have a daughter, 3 years, Your Lordship. And here section 109 attempt to murder not applicable, Your Lordship. Now, guardian of both the parties already settled the dispute, Your Lordship.
Yes,
On the
on 25/6/25.
After 2 days of arrest, Your Lordship.
Stage of evidence test. That is this.
No any single witness stayed was still dead, Your Lordship.
Court is vacant.
Long delay, about 37 days delay.
Now, are they separated? No, husband and wife, or they've
He is
resolved?
custody, Your Lordship.
No. Separated means are they still married or they filed
No,
their
it's the very
divorce or something?
Exist, Your Lordship.
No, that's what I'm saying.
It still exists.
But they are estranged. Some. Okay, we can go. Third, Spencer. Petitioner invoking 483 seeking regular bail in connection with Howley PS case number 71 of 25 under so and so section. He was arrested on 23/6/2025. The allegations in the FIR dated 5/6/2025 by the petitioner's wife is that on 29/4/2025, while she was coming with her minor daughter and mother, the petitioners, there are 2 petitioners, the husband,
Only husband.
the accused number 1, along with accused number 2 of the FIR, assaulted her with a dowel, causing head injuries, and then she was rescued by the local people. The accused number one of the affair is the present petitioner, being the husband of the informant. Full stop. The case was charged sheet and presently pending as Sessions case number 102 of 2025 before the learned Session Judge, additional Session Judge Barpeta. Full stop. At the stage of trial, right? At the stage of trial.
Yes.
The scan record has been received. Witnesses have not been examined.
Not examined.
However, the prosecution evidence has not yet started. Full stop. It is submitted by the petitioner counsel that informant and the accused being husband and wife have also settled the matter in the meantime. Nevertheless, considering the stage of the case and the length of detention, the accused so and so is hereby allowed to go on bail of rupees 30,000 with one security like amount, the inspection of the concerned learned court. Additional Session Judge Barpeta. And subject to the conditions, that number one, he shall be available for the remaining trial. Number one, shall not hamper or tamper with evidence. He shall not in any manner cause any harassment or harm upon the informant who happens to be his own wife. Stop. Violation of bail conditions shall entail bail cancellation. Stop. The bail petition stands allowed. Disposed of.
Obliged.
17.
Wait, please, is a motion. Motion you kindly find FIR at page 9 of it. I am in custody since 76 days as on total option.
What happened actually? What is the allegation? The only
103
shop
is there.
lives there, it's in house of the owner. Son of the owner doesn't fare. He had let me know. You don't know. Or-
Police took me in police remand for 3 occasions lordship. For
occasions.
6 days I was in police custody lordship. So I am thoroughly interrogated during that period lordship, 76 days as on today lordship. And lordship, police could not reveal anything. There is another angle, lordship may kindly come to page 5 paragraph 7. Yeah. The petitioner's brother was murdered some days back lordship. And the victim of the present case saw that accused person in murdering the brother of the petitioner. That may be one of the reason lordship.
Yes, ma'am. What happened? The victim was an eyewitness of the incident of murder of the petitioner's brother.
Yes, sir.
Okay, he saw the accused Suman Mandal while murdering the brother of the petitioner. The petitioner cannot commit murder because he was the vital
Yes,
witness.
He was the main witness of his brother's murder.
It's an
lordship.
interesting angle.
How he can be involved lordship, how he can.
Let us see Annexure 5
Lordship.
before I go to the
Page
prosecution.
26.
26.
Isn't it bail application filed by that accused person?
Suman Mandal. Sorry. He's an accused, Suman, that's Suman Mandal in this Kajalgaon. Diary or diary?
Diary. Opinion is pending.
Completely circumstantial evidence.
Yes, opinion regarding the cause of death is kept pending till the receipt of toxicological and chemical analysis report from DFS diary paralysis. And in postmortem report, ligation mark, a continuous ligation mark of size 30x1. Pain is present horizontally, encircling the whole of the neck of the level of the thyroid cartilage. So ligation mark was continuous. And in his confessional statement, yes, fully admitted that person, yes, he is strangulating with a seat belt of a. Can go to the statement of the last part of the.
His statement to his mother that there was a quarrel.
Yes,
Yeah.
Before
Before that,
yes, his brother was killed by this.
therefore she suspected that
Subsequent,
if say during night time.
now he has admitted.
He had told his mother about a quarrel
Yes.
with the son of the owner.
In the affair of lordship. In his temple lordship, he has took the previous lordship, and as per the statement, lordship can go for it, lordship.
But save time, you know. So what is your submission? When was he arrested?
Arrested on
410.
310 lordship, and 410 he was forwarded. 76.
What are the materials against him so far?
He has with a pre-planned manner, lordship, he has brutally murdered the person. lordship.
That other angle?
Other angle was there. That's why he has, as per his statement, that's why he has. Why he asked him that why did you kill my brother? Then he said that bad day.
No, he's not. He's supposed to be a witness to the murder.
That part is yes.
Let us refresh it again because these are facts are intermixed. You know, it can lead to confusion. No issues. So he says that this one allegedly so and so Mondal killed his brother,
Yes.
and he was an eyewitness,
Yes.
the victim of this case. Okay, Saha, victim. He was a victim and vital witness. So he has contended on instruction that he might have been killed by that accused also, but the accused is in custody.
Yes, lordship.
He's in custody at his behest. So that's why I'm saying, is there any angle relating to that, or it is that is pursuant to the quarrel, which is a straighter line? There was some quarrel, and then he tried to kill him or killed him.
Length of detention lordship 76 days in custody. Yeah. That's a good one.
Against him, or things are still emerging.
Yes, the body was lying on a peatland lordship. So that's why. Last part can go for lordship. Yes, I have like marked up. Yes.
Where?
This is the apart from that lordship. Yes. Last part from the last portion.
So complicity may be there.
Yes. At least this.
Handwriting is not very good. Ligasa mark is there. No, that is the mode of death. The thing is that who? Shivani Saha. Shivani Saha, the informant has stated the same thing.
Yes. He killed his brother that in on anguish on that day. So why you kill my brother? And on anguish, he strangulate the neck of the wrist with his seal belt.
In that case,
Yes, still.
lordship, in that case, provocation part is there, lordship. And,
complex circumstances. That means he suspected the involvement of the deceased also here in that. But not only that, Mandal, along with this.
That's why he searched him.
Ten. Whatever it is.
So vacation is there, Lordship, and length of detention may be considered. Long vacation is also ahead, Lordship.
Let me think. Mr. M.I. Hussain, learned counsel for the petitioner. Accused petitioner. Who is in custody. Again, invoking 483 BBNS, he's seeking regular bail in connection with Basugaon PS case number 22 of 25 under section so and so BNS. Full stop. He was arrested on 4/10/2025. The FIR has dated 3/10/2025 was lodged by the mother of the deceased with the allegation that her son, her son Rajesh Sutradhar, her son Suraj Saha used to ply the e-rickshaw of the petitioner's father, and he had a quarrel with the petitioner on that day regarding fare. Later in the night, he was found to be without his mobile phone was found switched off, and subsequently the police informed her that his dead body was found. She has alleged that the petitioner, who is the son of Rajesh Sutradhar, had killed her son. The investigation, it is submitted by the petitioner side that apart from being in custody since 3/10/2025, he has also been in police remand for 6 days, spanning 3 occasions, during which he has been thoroughly interrogated. The investigation has progressed, and I've seen the case diary. I've perused the relevant portions of the case diary. Primary facie, the materials revealed is that the brother of the accused petitioner was earlier allegedly murdered by one person, in which the deceased of the present case was also allegedly involved. And on the date of the incident pertaining to the incident case, there was a quarrel between the petitioner and the deceased over this, and due to casual reply of the deceased on the subject of the alleged murder of the petitioner, he got angry and strangulated him, and subsequently disposed of his dead body, threw away his dead body. The crime scene has also been recreated by the police on the basis of the statement of the accused and with his assistance. Also, recoveries have been made. However, the investigation is not complete. Considering the complex nature of the circumstances giving rise to the alleged crime. the cooperation rendered by the petitioner during his custody and also length of detention. Dash, I am of the considered view that granting bail to him at this stage may not prejudice the ongoing remaining investigation. In such view of the matter, he is allowed to go on bail of rupees 40,000 with one surety of the life amount to the satisfaction of the concerned learned court, which is Basugao,
Sirang Kajol,
Srirang.
CJM Sirang.
CJM Chirang. And subject to the following conditions, he shall not abscond. Number 2, he shall cooperate with remaining investigation. Number 3, he shall not hamper or tamper with evidence. He shall not in any manner harm, harass, or intimidate the informant who is the murderer of the deceased. In case of violation of the bail conditions, the bail shall be liable to be cancelled. Return back the case, the bail petition stands disposed.
Deeply obliged.
That statement of his can be a dying declaration that there was a quarrel. But maybe
This may be recording this.
obliged. That's a matter of trial.
18,
Return, disposed.
May please, my lord. The 483 application, my lord. Allegation against me, my lord, 1031 and 3/5, my lord, of BNS, my lord. Lord, I was arrested on 29/09/2024, my lord.
Under what is the what section?
Section 1031.
Murder case, no?
Yes, my lord. Arrested on 29/9/2024, my lord.
29/9/2000. Let us see the FIR.
Yes, my lord. FIR case
Can
13, my
cooperate.
lord.
10 rupees come, madam.
Here, my lord, I am pray for default bail, my lord.
Here,
Yes.
here. Okay, tell me.
Then my lord, FIR was registered and my lord, charge sheet submitted on 28/08/2025. After 11 months, my lord.
28.
08 2025.
He was arrested on.
29/09/2024.
Nice.
What happened, my lord? Page 19 is my lord, default bail order by the Honorable CGM, my lord.
29/9/2024 and CS was on
28/08/2025.
11 months. Okay, tell me. Like,
Then my lord, there is a order of Honorable Chief Judicial Magistrate, page 19. Default bail order, but due to insufficient sureties, he could not submit bail bond, my lord.
oh, he has already been granted bail.
Yes, my lord. Thereafter, charge sheet filed, my lord, on 28/08/2025. Then Honorable Session Court rejected his bail fear, my lord,
Subsequently.
subsequently.
I see.
That is my case, my lord.
LADC, no?
Yes,
Perusal, it's in there.
Mandatory period is 90 days.
But he could not file
Yes,
commit
my
bail
lord.
bonds.
He is a 4-person.
No, it could have been reduced or nowadays to we release so many people on personal bond. So many people, even in serious cases. Never done before in my career. Lots of people were released. But anyway, it's a different thing now. So subsequent petition was filed after charge sheet and then it was rejected.
Yes, my
You have the
lord.
order.
Page 28, my lord. Relevant portion is page 29, para 2, my lord.
Yes.
It is submitted by the learned counsel for the accused person that the accused are innocent and they are falsely imprisoned. It is also stated that in the earlier order dated 28/12/2024, passed by the learned CGM review, the accused was allowed to go on bail by furnishing suitable surety for an amount 20,000 or like amount of suitable surety, but due to non-finding of suitable surety, the accused failed to submit surety for his bail till commit of this case. it is further submitted that there is no scope of tampering evidence or hampering investigation. Learned additional public prosecutor has objected to the grant of bail, containing that the case is pending at the stage of evidence and the vital witnesses of prosecution has not yet examined, and there is high possibility of hamper and temper of the evidence. Thereafter, my lord.
Now will he be able to give bail?
Yes, my lord.
Surety?
Yes, my lord.
Yes. take it. Forward. Make the submissions of them. Both of them. Just, yeah.
My humble submission, my lord, his fear for default bail is cannot be considered at this stage. Because, my lord, he was granted default bail.
Was granted.
But due to non-furnishing of the bail bond, my lord, my lord, he was not released on, my lord, bail. Therefore, my lord, on 28/8/2025, charges submitted, my lord.
Mhm.
Now, my lord, there are several apex court decisions, my lord. If he seizes the right,
Sanjay Datta.
seizes Sanjay Dutt and my lord, other decisions, there are also
Okay,
other
Ashwin
decisions,
Thakur.
my lord. If he
So
seizes
the
the
right
right,
Jesus
yeah, right seizes, my lord. Now, my lord, this application has to be considered on merit, my
on
lord.
merits.
On merit, my lord.
I think, right, that's right.
Now, my lord, he is, my lord.
I am not
I mean-
objecting, my lord, since he was granted, but
Go, but
question is
again-
that,
Yes,
my lord,
already 400 for
default
taken,
bail,
my lord.
default, he cannot be released on default bail, my lord.
You're right, actually.
And my lord, kindly say, my lord, 28/12/2024 granted default bail.
Mhm.
And charges submitted, my lord, in the month of August, my lord. After around 8 months, my lord.
8 months of grant of default bail.
Charges submitted, yes, after default bail was granted on
11 months, 8 plus 3,
2024.
yes, yes.
Yes, my lord. During that period, my lord, they have not filed any application.
Right. Witnesses have been examined.
No, my lord. Charges has been framed, my lord.
But
16/10/2025 charges framed, my lord.
He informed, my lord. Our High Court has a, in this matter, my lord, one judgment till, my lord, may be taken tomorrow, my lord. I will.
And my lord, there is also 183 of the statement of the witnesses, my lord, who is also my lord. Since he has implicated, my lord, both the accused person, my lord.
both
There
the-
are only one accused person, my lord, but he has implicated the other accused person also.
it's not very,
The second page is upside down, my lord.
mm. Uh, what circumstances the alleged offense took place?
My lord, this is the fight between the husband and wife, my lord. So husband assaulted the wife, my lord, in my lord, in intoxicated condition, my lord. Then I have also perused the postmortem report, my lord. There are some injuries on her head, my lord. And my lord, this petitioner, my lord, he has also assaulted the victim, my lord. This petitioner, my lord, he has also
He's not the husband.
he's not the husband, my lord. Husband is my lord, Mohesh Nayak, my lord. He could know.
And she has died.
He died, my lord.
Anyway, so it's. Third. No? Narje Borwa. Additional PP and 483 bail application. For seeking regular bail for petitioner Moniram Nair in connection with Dibrugarh PS case number 390 of 2024. He was arrested on 29/9/2024. The allegation in the FIR against two accused persons was causing assault and leading to the death of the victim, who was the wife of
Manoj Nayak.
the present petitioner. Sorry,
No, no, no.
the
Wife of Mano-
wife of one
Manoj Nayak.
Manoj Nayak. Most of Manoj Nayak. The case was charged sheet and trial commenced by way of Sessions case number 209 of 2025. Full stop. Though charges have been framed, the prosecution evidence is not, it's not. Full stop. this, the facts which have emerged is that as the charge sheet was not filed within the statutory period of 90 days, comma, the learned court bailiff was pleased to grant default bail to the accused by order dated
Order dated, my lord, page 19,
28,
28, 12,
I'll
2024.
find out.
Page 19, my lord, 28, 12, 2025,
Right, order dated 28/12/2024.
24.
Semicolon, however, the petitioner was unable to furnish bail bond, supposedly due to his poverty. And in the meantime, the charge sheet came to be filed after a few months thereafter on 28/8/2025. The subsequent bail application was rejected on 16/10/2025 by the learned additional session judge, Dibrugarh. Mr. Borua, the learned counsel, learned additional PP submits that as per the settled law, as the petitioner could not furnish the bail bond and the charge sheet came to be submitted subsequently, his right to default bail stood forfeited, and therefore this bail application has to be considered on merits. So I find the said contention to be correct. The scanned copy has been received. It was submitted that there are implications in the revealed by the investigation, including the statement. So whose statement was recorded under 160?
That is the nephew, my lord.
Nephew,
Nephew of the victim.
including the statement of the victim's nephew, recorded before learned GMFC. Full stop. Nevertheless, considering the considerable length of the detention and also the earlier circumstances in which the petitioner could not avail the benefit of default bail due to his poverty, I deem it proper to grant him bail at this stage. In such view of the matter, how much should we leave? 15,000? 20,000? Can you give 20?
Before
20,000. See, you can always pray for reducing it if you cannot. 20,000 with 1/0 of the item to the satisfaction of the concerned learned court, which is additional session judge Dibrugarh.
Yes.
Stop. And subject to the condition that he shall not abscond, available for trial, not hamper or tamper with evidence, not harass, intimidate, or influence witnesses. Violation would enter. Allowed and disposable.
Oblation.
And just come.
Your Lordship.
October.
This was 2810, Your Lordship. There are other series of affairs, Your Lordship. Even in those cases, these petitioners were not arrested, Your Lordship.
Right.
Now 41 days behind bar, thoroughly interrogated by taking them into custody, Your Lordship, by the CID, Your Lordship, and other accused persons, more particularly this Pani Fukon and Vikas Borua. These two were arrested and they were taken from this place to that place here on a different
In this
cases.
bail petition, how many petitioners are there?
Two, Your
Two
Lordship.
petitions.
Two petitioners.
Tanmoy Chetya.
Lordship, the further custodial detention
Paul
probably is not required so far as these persons are concerned, Your Lordship. And 41 days behind bar, personal liberty is in question, Your Lordship. They should have produced the case there before this honorable court today, Your Lordship.
Tanmoy Chetya is named as.
He was not named, Your
Oh, he
Lordship.
is not named.
Not named.
Subsequently, he is arrested.
He arrested
Gopal
only Your Lordship will
Paul Doctor is also not named.
not named. Your Lordship will kindly see the forwarding, page 32, last part, Your Lordship.
Page 32.
Here also there is no specific tact attributed to these petitioners, Your Lordship. These two petitioners. During the course of investigation after registration of the case, the complainant as well as witnesses were examined. Their statement was recorded under section 180 BNSS 2000. From the statement of witnesses and the investigation so far conducted, it is revealed that FIR named accused persons along with their other associates have been doing illegal activities like so and so, so and so, so and so. economy in the state of in the name of Bill Asit Sena, under the above section, below noted accused persons are highly required for detention. These are the, your lordship,
Style.
and thoroughly interrogated, your lordship. Custodial detention was there. They have interrogated thereafter judicial custody. They have never been interrogated again.
What are their demands? You said, no, they have some demands. That's some
Demands.
socio-cultural demands or something like that. GLS. Anyway, I heard about this.
Your lordship, in fact, your lordship, when your lordship, they are starting demanding that your lordship period, your lordship, the justice for Jubin Garg and they are holding prison, that's thereafter these affairs come, your lordship. Suddenly, all of a sudden, your lordship, this has been in existence since around your lordship 20 years, your lordship. All along, no action, suddenly.
And another thing, of course, this does not pertain to just two persons are not named also, but this
Other
because
accused
many of them have alias names, you know, and
Because Osam.
no, any person can write one's name in any manner. That's no nothing. But the problem is that this thing, as we know, whatever from my practical experience,
These
so
are
now it was
these
initiated by
yes, your lordship.
there was this writing this word that is the name of our state. As
Is-
the name was
he has
initiated
a
by Alpha.
Particular.
Alpha organizations.
But so far as we are
and they
concerned,
have
we
also have their share of extortion activities. So what I am trying to say is that, and this is known to the security establishment.
Lordship.
So if a lay person also writes this, that he may get into some trouble
Lordship,
sometimes. So this is the thing. So they have this, all these.
But we have no so that
But
yes.
because here he's not named also, of course. Now we'll see the investigation. We'll see the investigation. Diary has been received.
If the case there, my lord, the investigation shows, my lord, they have the, my lord, entire, my lord, be Rasid Khana, my lord. Although, my lord, the some of the, my lord.
I will
let's say-
record the submissions only now. I mean, I'll just study it and give it later, but in chamber dictation, but I will record the submissions. So you kindly make the submissions.
All the witnesses, my lord, they could not name each and every members of the, my lord, organization, my lord. But they have said, my lord, they were, money was extorted from them, my lord, out, and they were by showing fear, my lord. And accordingly, they paid, my lord, 10,000, 5,000, my lord, whatever money demanded, my lord. But there is also other allegation, my lord, against them, my lord. But my lord, the witnesses, my lord, who have, my lord, given a statement reporting.
Other allegations like?
Other allegation like, my lord, by doing some work, my lord, they have demanded money, my lord. I have also shown one statement, my lord. There's a lady, my lord, she was having some other problem, my lord, then they have, my lord, they have stated that, my lord, we'll do your work, but you have to pay this much money, my lord. These are the allegations, my lord. And my lord, the central committee, my lord, they have not authorized them to collect money, my lord. But personally, my lord, they are collecting, my lord. That is why, my lord, extortion has been, the case under.
In the name of organization.
Organization, my lord. The investigation going on, my lord, it is not completed. A material has been collected against them, my lord.
Lordship will kindly see one aspect, your lordship. Okay. One aspect, your lordship. Your lordship, if that is why I have been submitting at the initial stage, your lordship. If someone individually committing crime, your lordship, that for that entire organizations cannot be taken into task.
Taking the name of Bill.
Lordship, that is one. And secondly, your
You have to
lordship,
distance, if those, suppose somebody is doing illegal activities in the name of an organization,
lordship,
the organization has to
lordship.
come forward and delink.
And in fact, your lordship, when first the Dispur police case was registered, those persons who are involved, they have been suspended from the organization, your lord. That's, and your lordship will kindly see, secondly, your lordship, ultimately, your lordship, whether custodial detention is required or not, that's the question. It is not an anticipatory bail application,
Yes.
your lordship. They have already been custody for 41 days, your lordship. And ultimately, your lordship is neither punishing your lordship. Your lordship is looking at whether that custodial detention is required or not. After thorough interrogation, they are in judicial custody. Thereafter, your lordship, they have, your lordship, not been interrogated again by the police, your lordship, CID, your lordship. That makes a case, my case for your lordship bail. Your lordship may impose stringent conditions. I will abide by that. We will abide by that, your lordship.
I'll look
Lord.
into all.
My humble submission, my lord, investigation is still continuing, my lord.
Continuing.
And my lord, there are other witnesses, my lord, who are yet to be examined, my lord. So if they are released on bail, my lord, they may again hamper the investigation, my lord. Because they may threaten the witnesses, my lord. After coming out from
My last
the-
question would be, yeah, I noted that. Any specific materials with regard to these two persons?
These two, my lord,
Same kind of
yes,
allegation.
my lord, same kind of affair, my lord, and they were present, my lord, while demanding money, my lord, by the other person, my lord.
They were present. Anyway, 41 days.
41 days, your lordship, and ultimately, your lordship, it is the bail is the rule, jail is the exception. That is the
True.
principle, your
It's true.
lordship,
It is always true.
lordship.
It's a balancing exercise, as you know, but still there
For
is
that,
the
my
rule.
lord, for your lordship, my lord, perusal, my lord,
I'll
just
take it also.
wanted to show, my lord, one, exceptionally one witnesses, my lord.
I'll not dictate the full order here.
Not necessarily, my lord, that she can agree both of you, my lord, go and demand money, my lord. If I demand money and my colleagues are with me, my lord,
Mhm.
it will amount to, my lord, they are.
On
also-
large scale extortion,
Yes,
actually,
yes.
it can disrupt economy.
Yes.
Because it will affect what we call ease of business. It has many dimensions, right? Ease of business has many dimensions, including this aspect that people should be, you should not have fear.
They usually collect money, my lord, from the non-Assamese, my lord. From the non-Assamese businessmen and, my lord, the other small businessmen, my lord. And also, my lord, the local businessmen also.
Lordship, we have never touched, your lordship, the people from indigenous community. We have raised certain grievances, your lordship, non-use of, your lordship, the Assamese language, your lordship. When, your lordship, the indigenous boys are, your lordship, subjected to torture by, your lordship, the non-locals, your lordship, then we raise our voice. These are, we are doing ultimately, your lordship, someone will have to raise voice in favor of these indigenous communities, your lordship. That's what we are doing, your lordship. And when doing so, if some elements, some members, your lordship, go astray and make such demand, your lordship, then, your lordship, entire organizations cannot be called into question for that, your lordship. And that too, your lordship, all along, your lordship, there is no statement at all, your lordship, no allegation, nothing, your lordship. Suddenly series of affairs come up against us, your lordship. That's, your lordship, suspicious, your lordship. That gives rise to a question of malice, your lordship, behind all that.
Please.
And this affair was also lost by police, your lordship, not by any individual. All the affairs, your lordship, lost by police, not by those affected or persons, your lordship.
Anyway, so
Lordship.
only submissions, particularly Rakif. Just little part. Invoking 483 BNS heard as Pathakur, counsel for the petitioners, and RJ Bora, learned additional PP. Invoking 483 BNSs, the two petitioners herein, namely so and so and so and so, are seeking regular bail in connection with CID PS case number 20 of 2025 under section so and so so and so. They were they were arrested on, they were shown arrested in this case on 6/11/2025. Full stop. The case was registered based on FIR dated 28/10/2025, lodged at the CID Assam by it was lodged by whom?
Lost by, your lordship, inspector of police.
By police official in the rank of inspector CID. The elaborate narration in the FIR, but the gist of the allegations pertain to running extortion activities by the named FIR named persons and along with their associates belonging to one organization, BLS, and running such extortion activities by way of in the nature of organized crime and syndicates. Okay, factually correct. Good stuff. The learned Mr. Bothakur, learned counsel submits that the petitioners are not named in the FIR, and yet they were arrested in this case, and so far they have been in custody for 41 days, and during this period they have also been custodially examined. They have also been custodially examined. Full stop. It is
For
submitted
5
that
days, your lordship.
for as many as 5 days. It is submitted that the allegations are of vague nature and lacking in specifics, full stop. It is also submitted that the the allegations against the petitioners are malicious in nature, and the case has been filed by police official. Full stop. It is submitted that the petitioners, if granted bail, shall render full cooperation to the investigation, and they shall and abide by any conditions imposed. The case diary has been received. The learned additional PP, Mr. Borua, submits that investigation is not yet completed, and the investigation has lent support to the allegations about members of the purportedly representing the said organization indulging in extortion activities across the state. Full stop. With regard to the present petitioners, the learned prosecution submits that the statements of a witness indicate that they were present when some extortion was committed. Correct me if I'm full stop. I perused the relevant materials, including the case diary, and given my anxious consideration to the matter at hand. ...
Deeply obliged.
Chamber petition. Right.
Obliged.
Yeah, disposed.
2021.
May I please, Your Lordship. 20 and arising with same case diary, Your Lordship. Your Lordship, can you take up 20, item 20, Your Lordship? 3 petitioners before Your Lordship. They are all the petitioners.
At minute. Discussion passes the meeting. Yes.
All the petitioners are family members, Your Lordship, in both the cases, Your Lordship. The FIR, Your Lordship, page 11, Your Lordship. They are behind the bar for 45 days and 36 days. This FIR is a counterblast of our FIR, Your Lordship. Page 11 is the FIR condition. There is some excerpt in the FIR, but in fact, there is a quarrel between two families in our house. Here. They belong to a different place, but they came to our house. At the time of marriage party, or a DJ music set was playing by the youths. They came to our house, destroyed our DJ music set, and assaulted our family members. We have lost affair, and thereafter, after coming to know, they have lost affair, but there is some exit in the affair that they received grievous injury.
13 accused persons.
Lots of all our family members.
The city not received today, man. Both the cases.
45 days behind the bar, Your Lordship. And our affair is page 21, Your Lordship. We have lost on 27/10. And marriage party was gone in our.
Let me just come to terms with this. This was registered as a case.
Registered, yeah.
This is Saptagram.
Page
67.
number, Your Lordship. 67. And we have lost in the local outpost, and they have directly in the police station. We have lost 27, but our have registered subsequently.
It was registered subsequently.
Subsequently, because we have submitted the FIR you lost before outpost, to local outpost, and they have directly at one base, they have directly to the police station.
The original copy is at which page? 23? Is it 23?
Page 14. Page
40?
Page 14, Your Lordship.
Page?
Page
1/4.
1/4. Both have received simple injuries as some information. Nobody was admitted hospital, but there are some excited in the affair that they admitted hospital. It's not so. In the affair also not specific there.
Just a minute. 66. This FIR was registered on 1/11.
No.
No, no, I'm just trying, can you help me with that? Was the original GD entries of which date? Because we have to see, you know, this.
Page 16,
Which one has been filed earlier in point of time to have a better understanding of what happened, right? Page?
Page 16, Your Lordship. There I have lost. Receipt
No, no,
of-
the FIR lost by your side,
Our side, Your Lordship, page 28, Your Lordship.
28.
We lost on 27/10. Before the outpost, Your Lordship. Rani was
Yeah, that's okay, yeah, that's okay. It does take some time,
But-
yes, I understand, I know that. I know that. Received and registered support ground PS case number 1, it was registered on 1/11,
one,
but you filed on 27/10.
27/10. Because he have sent to the police
Mhm.
station that.
GD is 4/11, yes. Any indication of injuries in the forwarding report? So as you said, if it's simple, then the allegation is exaggerated.
Exactly.
No, but some basis to determine that CD is not received.
Is there not received, my lord? That is, I mean, without perusal of the injury report, my lord.
We can fix
It
it
will
on,
trigger-
at best on 19th, otherwise you'll have to seek from the magistrate or trial court statutory bill if it gets over within this period. We can take a chance on 19th if you want, if you wish.
But-
Without, yeah, his prosecution is right, without seeing the injury aspect. It will not be correct to give the
There is-
interim bill.
In the FIR also not mentioned the what type of injury received, how affected him, nothing is. Only they have said that they received injuries, severe injuries. And admitted hospital, that is false, because Bilasipur and Sabatgram both are civil hospital, cannot refer one civil hospital to another, it is also exaggerated. They said that Bilasipur hospital referred to Kokrachar hospital, civil, both are civil
So
hospital. they are
that
not-
Lord, may kindly peruse, my lord, the
Forwarding
annexure to,
Huh?
annexure to, my lord, page 17,
17.
ground of PS, page 17, ground of PS, serial.
That's
number-
what I'm searching for, yes.
serial
page
number-
17.
Serial number 2, my lord.
2.
Yes. Consequently, Atikur Islam and Hafizur Haq sustained severe head injuries, while Burhan Haq hand was fractured. They have undergone medical treatment in critical condition at Brother Civil Hospital. So, madam, my humble submission, my lord, that the injury report along with the case diary may be called.
Be necessary, yes. It will be necessary. The case diary was called for along with the injury report, but it is not yet received. The petitioners were arrested on
Arrested on the
3/11
3/11/25.
the 3/11/25 and 12/11/25 respectively. Stop.
45 days or
Issue fresh requisition for the case diary. Then now you say the date.
Only we can take a chance on 19, my lord.
Otherwise, it will be in the middle of the vacation.
Yeah,
When is
okay.
the statutory period extended? Because they have two different arrest dates.
Who was arrested, who were arrested on 3rd, my lord, that will be expired, my lord.
Expired on
Yeah.
Expired on, my lord, on,
3rd Jan.
or not, my lord, in the month of December itself, my lord.
Now 31st.
Before 31st, my lord, on 28th, my lord, I think,
How come?
no, not 28th, my lord.
Not 20.
Okay, sir.
3/11, 3/12, 3.
Yes, my lord. 28th,
60
and my
days.
lord,
Somewhere around
45.
first or second.
the first, my lord.
First.
my lord.
It is 45
Second
days.
is open in the district court. What should I do? Support ground doubtful, but I will come day after tomorrow.
My lord.
Very
We can
wrong.
call it, my lord, but
Take a chance. Yeah.
Call for the case diary. Issue record first reminder for the case diary. Fix on along with medical report. Fix on 19. Two petitions are there.
Petition, same years. It is AB years.
So this is an AP.
AB years. Same affair, same. All are family members.
Arrest to
22, 23.
Publish.
May I please, your lordship?
Mhm.
This is my lord, the CD all for the two petition back together in this against same police station. That is Pathar Gandhi PS case number, my lord. And item number, my lord, 22, this is under section, my lord, 483, my lord. There, my lord, three petitioner before lordship. And they are behind the bar, 1 and 2, my lord, 61 days. And petition number 3, my lord, 62 days behind the bar. And there is a cross case also, and both the party regarding transaction of amount, this quarrel is happened. And both the party injured, my lord. There is a simple injury here. And CD and
CD receipt.
and injury report also was called for, my lord. FIR lordship, page 10. Here, my lord, petitioner Badrul number 1, accused number 1, 3 Kamrul Islam, and 6 Abdul Jabbar behind the bar. And others, Zakir Hussain and Salil Rahman and Zubair Ahmed filed the BAS bail application. Alleging, my lord, that on 13 October 2025, all the name accused came to their shop and has taken a profit of amount 3,50,000 and
Yes.
assaulted. This is the case. And there is a rival allegation saying that more than 5 lakhs are recoverable amount that has not been paid by the informant here in this case. And cross case filed by one Zakir Hussain, who is also accused in this present case, my lord. And so far, informant in the present case, Mahmoud Hassan, he is also accused in cross case. He committed this offense, my lord. Now, Lord, what the party injured, and section, although level 109, that is not attempt to murder. Case of voluntarily causing grievous hurt and theft.
Same incident arising out of
Same incident. On the same date, both the FIR lost, and on the same date, it was registered.
No, the incident is common
Common.
over the shop. Yeah.
It is present case, my lord. There is FIR lost on 13 October and registered on 14/10. And so far, our case is concerned cross case. There is also registered on 13/10/2025, case 23, lordship, and it was also registered on 14/10/2020. Same allegation.
So both the cities were called for lordship. Patrakandi PS case number 229 of the 25 and 230 of the 25. Only one received lordship. This is
What the CDs were called. This one,
229 of 25 lordship we have received.
that is received.
Yes. As per medical report, lordship, one person, Badaruddin Azmal, his injury is grievous by blunt weapon, lordship. One is Kabir Hussain, blunt press injury by simple. Other person was there, who is over blunt by simple. One is grievous hurt, Abul Kalam. Sharp object weapon. Grievous hurt, sharp by sharp weapon. Lordship. He had lacerated wound of size 4x1 centimeter cube. Noted left forearm 8 centimeter above. And lordship, witnesses were implicated, the petitioners, and the eyewitness, a victim also implicated, and the eyewitnesses are also there also. Regarding later part of the snatching money, that part is not the recovered and not in the case diary, lordship. Witnesses also stating that yes, they have.
But assault is there.
Assault is there. Witnesses stating that they have tried to looted 3,50,000, but that part is not by
Not
the. Otherwise, they have been implicated by the witnesses also.
Lordship, as more than 60 days, there's the bar. On the length of detention, my lord, further detention not necessary. By imposing any terms and conditions, my lord, this to be.
What is the investigation has progressed? And what about the petitioners in the AB?
Same is there. They have responding from the data incident.
Even if we consider this, AB may not be justified.
Yes. Considering only the length of detention, otherwise materials are there. But at this stage of investigation, AB is anticipatory bail cannot be considered.
No, it can be granted, but it may not be proper. May not be.
But, Lordship,
This we can see. This we can see perhaps. 483 bail application heard in connection with
Pathargandi PS.
yes, Patakandi 229 of 25 in the section swings. Registered based on an FIR dated 13/10/25 lost by Mahmood Hassan. Full stop. The
Mahmood Hassan.
yes, the petitioner number 1 and 2 were arrested on 16/10 and petitioner number 3 was arrested on 15/10/2025.
And one and Badrul and Kamrul, petition number 1 and 2.
Yes, sir.
160.
15 and 6, 1 days.
Yes, one day.
The gist of the allegations in the FIR dated 14/10/2025 is that the accused persons named in the FIR assaulted the informant with a crowbar and also robbed some significant amount of money apart from breaking his mobile phone. Full stop. It is alleged that they also attacked his family members, causing injuries to his father and others. Full stop. The Barnet Council has submitted that with regard to the same incident, cross FIR was lodged from the side of the petitioners, in which the informant Mahmood Hassan is one of the accused. And the said cross FIR was registered into Pathargandi PS case number 230 of 2025. Both the case diaries were called for, but the case diary of only Pathargandi 229 is received. Full stop. The learned additional PP submits that the investigation has revealed implications against the petitioners with regard to the allegations and lends support to it. On the basis of the medical reports available in the case diary, the learned additional PP submits that the incident led to injuries, simple injuries and grievous injuries. Grievous injuries on one victim and other injuries of a simple nature over another victim. In the given facts and circumstances, considering the length of detention, the accused persons, the accused petitioners hearing are allowed to go on bail of rupees 25,000 each, with a surety of the like amount each to the satisfaction of the concerned learned court, which would be Karimganj. Sribhumi. CJM Sribhumi slash Karimganj. And subject to the conditions that number 1, they shall cooperate with the remaining investigation. They shall not hamper or tamper with evidence. They shall not misuse their liberty to commit any offences or illegal activities. The bail petition stands allowed and disposed of under aforesaid terms. Return back the case diary.
Lordship, for item number 23, my lord, we fix after vacation. In the meantime, the cross case may.
What do you say? That is his suggestion, contention.
Metal shot again.
But our
File again if it's
our CD has.
The report was clear and the investigation sufficiently progressed.
In view of the incriminating materials revealed by the investigation and the injuries purportedly caused in the alleged incident, it may not be an appropriate case to grant anticipatory bail at this stage. Accordingly, the instant prayer for petition for anticipatory bail stands rejected at this stage. Return back the case diary.
Okay.
Disposed of. So keeping pending. Yes.
24.
Yes. Chadarka.
May it please your lordship. My lord, here petitioners were arrested on 25/10, my lord. FIR is at page, my lord, 21. Sorry, my lord. FIR is at page number 17. And basically, 17. No. Basically, allegation is that, my lord, petitioners are employee of a particular institution, my lord, which works under the NHCM, my lord. And NSD, National Skill Development Corporation. They work under that, my lord, in a company. My lord, out of the 3 accused, the accused number 1, my lord, who have been apprehended together, my lord. Accused number 1 is the authorized person, my lord. That one Manoj Kumar, my lord. He is the authorized person of that, my lord, that particular Extreme Private Limited. He is the authorized person, my lord, and allegation is that, my lord, under the NSDC, my lord, some students are recruited, my lord, and for that some money is paid to them. My lord, here allegation is that, my lord, some documents were forged relating to their mark sheets, my lord, and they have taken benefit, my lord. This is the allegation. Now, my lord.
Can I have a look? Let me have a look at the FIR once.
Yes, my
before I
lord.
Go forward.
Yes.
I'll read it myself.
Yes, yes. 17, my lord.
I'll just take 2 minutes to read it. 24 and reliable source input was received by OC for his tokens. It's a 1%. Okay.
My lord, I am pressing it on 2 counts, pardon.
Arrested on 25/10.
Yeah. Okay. My lord, 2 counts, my lord. One is that they are employees under that Manoj Kumar, my lord. That may be reflected in the diary. I do not know. My lord, they do not have access to any recruitments as such, my lord. That is my humble submission on merit. And another, my lord, at page 17, when my lord has gone through the FIR, my lord might have gone through that. 1 to 12 are the list which are recovered and seized.
Yes.
My lord, I pray this basically this case, my lord, is connected with, my lord, documentary evidence. And all these documents have already been seized, my lord. And 54 they are in custody. 54 days they are in custody. Perhaps, my lord.
Yes.
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 The statutory period is 60 days.
No, my lord. There
It's
is
90 days.
yes, because of, my lord, new
Organized
provision, my
crime.
lord. Yes, my lord.
See, that's right.
Otherwise,
Brought
earlier
also.
it was 7 years.
Yes,
only.
those things have been brought now.
Yes.
Sometimes it is necessary
Yes,
also.
yes.
Some cases, not necessary. Yeah. Depends.
Well, perhaps custodial detention further may not be required because everything has been their mobile phone, all documents, my lord, pertaining their electronic items, all were seized, my lord. And perhaps till now, my lord, statements must have been recorded, my lord.
Yes, tell me.
The investigation in the statement of the witnesses say they have collected fabricated certificate, the petitioners,
Hmm.
certificate mark sheets from students of different higher secondary schools. And for some mediators. And they use those mark sheets to enroll students under a PM Vikas Minority Project Skill Development Scheme. It's a government of India scheme. And when the students were selected, they benefited to be student received 22,000 rupees per month. Some cases they issued 4 certificates showing failed students are passed and collected money fraudulently from the scheme. On the basis of the statements of the seized exhibits, that these petitioners obtained monetary benefits under PM Vikas Minority Project by submitting fabricated and research records. And some documents were recovered from their possession. Some bundle of mark sheets, laptops, computers, cash of rupees 2,05,100 rupees. Some materials were recovered from their possession. And they invested money, these two petitioners, Alex Singh and other one of the invested money from the statement of the witnesses and other co-accused. So they went to the schools and collected certificates and mark sheets. And there are several persons involved in this record work.
Is that?
Am I able to, I have objection regarding this at this stage of investigation because several persons are there. Lots of persons we have to be arrested.
Hazarika, DP Goswami. 483 bail application. Bohishta PS case number 521 of 25. Under so and so section. So, which was registered which was registered based on FIR dated 24/10/2025, lost by it was lost by police official. By SI Tithoteka, Bohishta PS.
Yes.
Stop. The present petitioners were arrested on 25/10/2025. They are also named in the FIR along with one Manoj Kumar. Stuff. The gist of the allegations is that the petitioners indulged in fabrication of academic documents to enroll students under the PM Minority Skill Development Scheme, whereby students receive rupees 2,000 per month, and that they by indulging in such fraudulent activities, they wrongly enrolled in such. They wrongly and illegally enrolled in such a scheme. Persons who were who did not fulfill the criteria, and thereby cheating government money, misappropriating government money, and also depriving genuine beneficiaries. The learned counsel, Mr. Hazarika, submits that they have been examined and they have been in custody since 54 days. It is submitted that they are only employees of the main accused, Manoj Kumar. Full stop. Semicolon, that the case is based on documentary evidence, most of which have been seized. In this backdrop, in this context, it is submitted that perhaps granting of bail at this stage may not be detrimental to investigation. On the other hand, the learned and Mr. Goswami, the learned additional PP, on the basis of the received case diary, objects to the grant of bail at this stage, submitting that the investigation has lent support to the allegations and revealed the involvement of a network, a wider network in this fraudulent activities of manipulating documents to confer benefits of the aforementioned government scheme upon persons falling outside the criteria. Falling outside the criteria. It is submitted by the learned additional PP that investigation is continuing into the involvement of other persons. I have given my consideration to the materials as well as the submissions. At this stage, I find force in the prosecution contention and therefore we deem it fit to reject the bail at this stage. The bail petition accordingly stands rejected at this stage. Return back the case there, right?
Obliged, ma'am.
Sometime.
25,
Need we have bail.
Mate,
Yes.
but CD was called for, madam.
Right.
583 application, madam. What you will see, the FIR page 13, madam. Mary. In Jurassic on 19/10/2025 at about 12 p.m., my sister named Benso, aged about 19 years, died of hanging. According to the cause of death of my sister, that there had been a love affair with the accused person by my sister since 1.5 years back. We found the accused person mentally tortured my sister over phone and often made demands and threats over phone. For these reasons, my sister stood the way of the law. It is therefore prayed that you honor may be kindly. This is the after. Based on this matter on 31/10, my lord, the petitioner has been arrested, my lord, and as on the already, my lord, 48 days he is behind the bar. And as far as been registered under section 108 of BNS, my lord. Now, what happened, basically the love affair with the, my lord, deceased, my lord, with the admitted fact. There is a love affair with the petitioner as well as the victim, my lord. And so far, that love affair is considered the matter triangle one, because one another boy was with the girl, my lord, and with that particular boy, my lord, she wants to marry at one time to the petitioner and the other time to the other person. Now, what happened? The petitioner is the third year student, my lord. He is studying in the polytechnic school, my lord, at third semester, my lord, at Bortata, my lord. During their love affair, the victim pressurized the petitioner to get her married, my lord. But at the telephone time, the petitioner said that since we are in the tender age, my lord, we have to complete our study. You also complete your study, I also complete myself, then we'll decide the matter, my lord. What happened, my lord, during that period, my lord, when the petitioner has come to know that she made a love with another boy, he refused to get married with the boy. This is the practical, my lord, situation that the petitioner has faced, my lord. Basing on this, my lord, after a long period, my lord, without, my lord, explaining the delay, the affair has been lost, whereas the incident was taking place in 1910. Affair was lost after, my lord, 10-11 days, my lord. Basically, on the suspicion that since there is a love affair with the petitioner and the victim, some cruelty was done, mental torture was done, which has led to the death of the victim, my lord. This is the basic allegation. So for the affair reveals, my lord.
Investigation has
Investigation.
any aspect of viraling of photos,
Some
etc.
is just stating that, but I have 11%. I have
See that aspect, otherwise it can be considered.
Being that one VDP president of that village, I am aware that Navadip Sundaram had been in a love relationship with her for about 2 years. During that period, I had personally seen Navadip Sunwal frequently coming to the house of the deceased and sometimes staying there. Later I came to know that Navadip used to physically assault Priyanka in public places when he came to our village and often quarreled with her. So lots of
No, viraling of photographs, anything.
that part
Nothing is there.
That viraling photograph is not stating anything regarding that viraling of photograph.
Nothing is there.
With mentally
No
disturbed,
aspect.
mentally disturbed and physical assault in public out there.
19-year-old girl.
Lordship.
Well, petitioner is 20 years old.
20 years old.
20 years. Well, he is still having a bright future so far his career is concerned.
PM report not available in the CD, and the inquest report, there are some sketch marks in the wrist part, but that part is there also.
Already
No, he said mentally tortured, but that's why I asked you this question. Whether the aspect of blackmailing, that is not there.
already 48 days.
Then it can be considered, perhaps. Heard. 483, Morigaon PS case number 268 of 25, under 108. The accused was arrested on 31/10/2025. So the FIR dated 30/10/2025 lodged by the brother of the deceased.
Sister, my lord.
No, Borkha Rani, so sorry, Sri is given by the sister, younger, must be elder sister, whatever it is.
Eldest.
By the sister of the victim slash deceased. Alleged that on 19/10/2025, in the afternoon, her said sister committed suicide, aged 19 years, committed suicide. It is alleged that there was a love affair of her sister with the accused person since 1.5 years, and that the accused had mentally tortured over phone and made demands and threats, and therefore her sister died. So very relevant that aspect, that demands, blackmailing, this is not there. The learned counsel submits that he was arrested on 31/10 and already spent 48 days in custody. It is that semicolon that he is a student aged 20 years. It is also pointed out that there is an 11-day delay in filing the FIR, which has not been explained. It's not been explained. Good stuff. Abatement of suicide. It is submitted by the learned additional PP that the investigation is revealed from the testimony of some witnesses that the that the petitioner and the deceased had a love affair, but that he used to assault her, sometimes even in public places. Full stop. Full stop. Upon a query from the court, the learned additional PP submits that the investigation so far has not revealed any materials about viraling of any personal / private photographs or blackmailing, any blackmailing regarding the same. Full stop. In the given facts and circumstances, considering the length of detention, progress of investigation, full stop, and other circumstances as noticed above, including the age of the victim, age of the petitioner, dash. I am inclined to grant bail to him at this stage. Accordingly, 30,000 with 1 security, subject to the condition that he shall cooperate with remaining investigation, he shall not hamper or tamper with evidence, and he shall not in any manner harm or harass or intimidate the informant and her family members. In case of violation of bail conditions, the bail would be liable to be cancelled.
May it be 20,000 security amount?
I gave how much? No,
30,000.
20,000? Okay, no, 20,000. 19-year-old girl. Why should someone commit suicide? Life is so precious. You know, I always feel that if somebody, actually it's a cry for help, but which did not go answered. I feel that if somebody has this, thought of committing suicide, that person should think of his mother, who spent sleepless nights to bring her up or him up. At least for others, at least for mother.
Yes. Lordship.
So this is regular bail application, Lordship. Can this case, Lordship, be? And I'm not on merit, Lordship, and some documents I have annexed, Lordship. Can you come to page number 21, Lordship? The petitioner is an established businessman, Lordship, and some cash money, 5,90,000 recovered from his residence, and subsequently, Lordship, some ornaments has been recovered from his godown, Lordship. And can they come to page number 21, Lordship? And he's established businessman, Lordship, and the income tax pay, Lordship, and he's also license holder, Lordship. And page number 21, annexure 3. And he is doing business, Lordship, 1/1/2022, and he is the registered business person, Lordship. And Lordship, another Lordship, and income tax return verification, Lordship, that is page number 22, Lordship. In the name of the petitioner, Lordship. And Lordship, onwards, Lordship. And Lordship, and he has been suffering from various ailments, Lordship. I have annexed, Lordship. Finally comes page number 29, Lordship, operative performance, Lordship. And he is a heart patient, Lordship. Page number 29, Lordship, and the increased level, Lordship, in middle, Lordship. Chronic renal failure, heart failure, and chronic soul, Lordship. These are the disease he has been suffering, Lordship. And Lordship, another, Lordship, and he is the only earning hand of his family, Lordship, and to one son and daughter, Lordship. And his daughter is appearing in the examination, Lordship, that is page number 30. And program schedule, Lordship.
Class 10.
Conduct, Lordship, class 10. And pre-board examination, Lordship, it will be start from 2012-2020.
Pre-board exam.
Lordship, day after tomorrow. After 2 days, Lordship.
What is the allegation?
Allegation, Lordship, and his one brother-in-law, Lordship, FIR number accused number 2. And allegedly, Lordship, in the FIR itself is clear, and some ornaments, Lordship, kept in his godown, Lordship. But actually, Lordship, in the contents of the FIR does not reveal, but something is revealed, Lordship, and he has the knowledge. But otherwise, Lordship, the petitioner
Let
had
me
no
see,
knowledge.
just a
Lordship.
inform that on 2/2/20.
Main, Lordship, page number 15 is operating, Lordship. FIR lodged by police.
I'm seeing it. I'm going through the FIR.
Lordship.
Search operations.
And there is no any individual person and either local person raise any objection against the petitioner or lodge any complaint, Lordship. But otherwise, he is an established businessman. So, my lord, only the local person, Lordship, and the ground of Lordship and can be considered, Lordship. There is no any other individual.
Saidul Islam is arrested. Saidul Islam.
No, Lordship.
He's not arrested.
He is not arrested. And he is the brother-in-law of the petitioner, Lordship.
He's the brother-in-law of the petitioner.
Petitioner, Lordship. And if he keep, Lordship, but that is no knowledge of the petitioner. But subsequently, allegedly, FIR is mentioned, Lordship, and he has the knowledge. Only that much allegation is against him, Lordship. But not his dwelling house, Lordship. And so far, section is concerned, Lordship, and section will not come against the present petitioner. Theft, Lordship, and transparency, either 305A, Lordship, and T5C, 305A, and theft in a dwelling house, Lordship. 305A, 2 lines of language.
Yes.
305A, Lordship, and subsection A. Theft in a dwelling house or means the transportation or place of worship. And A, in any building, tent, vessel used as a human dwelling or used for the custody of property.
Stolen property.
Stolen property.
Anyway,
But we have not received a case diary in this case.
we have not received the case.
My humble prayer, Lordship, his daughter, Lordship, and he is appearing in the
It's
examination.
not
Lordship.
possible. Sometimes personal factors I will have to give way to, because so many recoveries. The source information was correct, that means to some extent at least, that it was being organized and stored. Large number of jewelries. Yes. The investigation, it will need thorough investigation. Anyway, case diary as called for is not yet received. Issue fresh requisition for the case diary of Soigao PS case number 326 of 2025. Full stop. Is the matter.
My one prayer, Lordship, only one attempt day after tomorrow, Lordship, only for examination is.
I can fix it, but it may not come. Okay.
Lordship.
Okay, no problem. I can fix.
27.
19, 12.
Lordship, 483 application, Lordship. The FI page number 14, Lordship. So 303 subsection 2 is there, Lordship. 317 is there, Lordship. 317 subsection 2 is there, Lordship. Lordship, actually, petitioner is a Lordship owner of a scrapyard, Lordship. Owner of a scrapyard, Lordship. He has 7 employees, Lordship.
Diary receipt, true?
Diary receipt.
Anyway. Yes. Go on.
Oh, yes. So he's the owner of a scrapyard, Lordship.
Yes.
So he has 7 employees, Lordship. Lordship, many Lordship economically, Lordship weak people, Lordship used to collect things from the Lordship road, Lordship, and used to give them lordship. The only this is the matter lordship. Lordship. And he took the things lordship in good faith lordship, and those the which in the FIR is written lordship that stolen property is not stolen lordship. Lordship is a all damaged things lordship. Lordship and in good faith only lordship these things has been lordship, kept
75
lordship.
kgs of copperware
Yes, lordship. Yes,
and
lordship.
cut piece form,
Yes, lordship.
2 numbers of swans of 3 numbers of sockets.
So 25 days lordship is in.
So materials were stolen, lordship, and he's the owner of the scrapyard, lordship, but recovery was made from his scrap.
No, the recovery is that he's cap owner, so this might be part of his thing also, but they are suspected to be stolen from airport construction site.
Yes. Returned the site worker visited the place of his scrapyard lordship and identified the articles that yes, those are the articles who were stolen from their site.
Who?
The workers of the site and the engineers are also the construction site from where the articles were stolen.
He was arrested on
22nd
22/11.
Yes.
483 bail application regarding on behalf of Ziaur Rahman seeking regular bail in connection with Azara Peace case number 174 of 2025 the section so he was arrested on 22/11/2025. As per the FIR dated FIR dated 22/11/2025 lodged by SI Simonta Bormon of Azara PS. Credible source information was received that stolen copperware is stored in the scrapyard of Ziaur Rahman. Stop. In that jurisdiction. Full stop that comma GD number 15 dated 21/11/25 was made, and thereafter the police team along with witnesses searched the scrapyard of the petitioner, and during such search 75 kgs of copperware in cut piece form were recovered along with some other materials, and that these articles were suspected to be stolen from the new airport construction site. It is alleged that the petitioner, as the owner of the scrapyard, could not explain the presence of the large quantity of copperware. The learned petitioner counsel submits that the accused petitioner is the owner of a scrapyard, and various persons of various poor people come to deposit scrap, and he denies that the recovered materials are stolen. Full stop. The case diary has been received, and learned additional PP, Mr. Goswami, submits that investigation has implicated the present accused persons and present petitioner, and the investigation materials, including statements of witnesses, have revealed about the said copper material being stolen as alleged. Stop. The given facts and circumstances, and considering that investigation is still in progress, bail is rejected at this stage. We'll turn back the case diary. Let it progress.
$28.
28.
In this case, my lord, there is a new section has been added.
1 minute. Huh?
Up to date city may be called for.
Because call for completing Nah.
Sorry, sir. I'll have to come to you.
Section 8.
Also,
Please before appropriate bench.
notification.
Okay.
Yes. What is the matter? This
As per his statement, new section is added, POXO.
POXO has been added.
POXO is added later on, Lordship, as per his
Letter.
statement.
Okay.
So, at this
Up
case,
to date city may be.
after the maybe qualified notice should go to.
Already.
Notice,
Sir.
sir.
So
Then
is
after
the
CD was called for, after the CD but not received yet.
There is an interim order, madam.
interim order is there, but service of notice where it is reflected in the order sheet. History. Well, there's an interlocutory application also. This is not necessary now. Oh, for implement.
Implement, party testimony.
So I'll dispose of this then. The interlocutory application has been filed by the petitioner side for implement of the informant as respond number 2 in this petition. In the context of the addition of penal provision of the POXO Act. So the prayer is allowed and Ghiasuddin is hereby shall be implemented in the bail application as respond number 2. In the IAS stands allowed and disposed of. First of this submitted case diary is not received. It's received?
Not received.
Not received. It is submitted. Mr. Akan submits that in the meantime, penal provision of POXO Act has been added, and therefore he has been added. First of White order dated today, 7 passed in IA 271 of 25, connected to this bail application. The prayer for implement of the informant as responded in the bill is allowed. Notice may be issued. You have issued the notice. You can issue the notice upon respond, right?
Yes, sir.
Notice steps of notice may be taken upon the respond number 2 informant through the office of the public prosecutor and to be executed by the concerned police station, which is that is Mankasar PS. No? Mankasar PS. Mankasar PS. The petitioner was granted interim bail on 26/4/2024. That's a long back.
Long back, yeah.
The interim bail will dispose it off. It's been pending for a long time. We should.
Other CD was here, but
Bail petition should not be. No, nowadays there's direction also, right? So we have to complete it. You can dispose of and then file again, but it should not be kept pending for such a long time. The interim bail is extended till the next date of listing. The issue fresh requisition for the updated case diary.
yes.
In the meantime, you quickly serve the notice, then we can appoint amicus if he's not present. Then we'll dispose it off. It has to be disposed of. Huh?
6/1/26.
6/1, yes, right date. 6/1/2025, 26.
29.
My lord, আজিও নাই নেকি এইটো? আইঅ'ৰ নামটো ওলাইছে। My lord, this IO, my lord, this total, my lord, today is the 22nd day. This case is being listed, my lord, is an anticipatory bail
Really?
application, my lord.
How can it be? Is it?
Before, my lord, on 10 occasions, 11 occasions, my lord, I was without interim. Then this court gave me interim.
Yes.
After interim, today is the 10th occasion I am here
My
to the
God.
case diary, my lord. Why should this court take up this matter every day? Why should I come to plead in this matter every day, my lord?
So
This,
what-
my lord,
what-
is the IO above the High Court, my lord? He's taking the High Court for a talk.
Nobody is, I'm also not above High Court. No, nobody is above law, actually.
Then, my lord, how can he do, my lord? Today he has not sent a case diary, my lord. Did he send any communication to the court that the order could not be complied for such and such reason, my lord? My lord, we don't make such submissions, my lord. We are very patient, my lord. 22nd day this case is coming
So
up
what
before the
should-
High Court.
What should be, that's.
This High
that's-
Court, my lord, High Court
No,
of the
no,
state,
no,
my
no,
lord.
any court, see, any court, any court.
No, my lord, what I mean to say, if they don't
Yes, yes.
don't care for the High Court,
Yes,
what will
what
be the
are-
plight of the other
yes.
courts, my lord?
Yeah, definitely.
I have to Namjogi. I just want to see, my lord, his name, my lord, for a moment.
What is this? This is not very bad.
No, my lord, he may be called, my lord, strict directions may be passed, my lord. In many cases, they do like this, my lord.
I'll have, no, this is, I've seen the pattern.
Let a precedent be set,
No,
set,
no,
my lord.
I've already seen the pattern.
Yes, my lord. This is a fit case, my lord, where precedent can be set, my lord.
Various vested interests are there in various sides to balance.
And my lord,
The prosecution becomes helpless.
let there be a direction, my lord. If IO fails to provide the case diary, let him send a cause and reason why he failed so. On each and every date, there has
Sometimes
to
they
be.
seek a date, sometimes they send a letter. Any letter has come today, nothing.
How can they do like this, my lord? On each and every day, the IO not being able to produce the case diary or any report, FSL report, whatever may be, they have to send some communication to the court. That shows respect, my lord.
What was the matter?
My lord, it's an anticipatory bail application under section 302 IPC. It's a matter is also serious, my lord.
True.
And my lord, this court earlier did not grant us interim bail. After the 10th occasion they failed to produce the case diary, High Court gave us, this court gave us interim protection.
Also, heard F. Khan learned counsel for the and DP Gosam. So the case diary as called for has not yet been received. The learned counsel submits that after the filing of this bail petition.
On 1/10/24, I filed it.
The matter was first fixed for case diary. Did it come once? Did not come ever.
It came once, but without the FSL report or something which was called.
Listed on case diary was called for and it was listed on 25/10/2024. Since you have made the submission, let me record it so that if it is disposed by another bench also, they will be guided. Stop. On 11/11/2024, the case diary was available, but PM report was not, and therefore it was directed to be sent back and procured again along with the PM report. Again on 22 B Spar 2024, case diary was received, but without FSL report, and whereupon case diary was returned back and directed to be procured again with up-to-date investigation along with the FSL report also. The same was received on 23/1/2000. The case diary was again received on 23/1/2025, but not accompanied by FSL report. And the same exercise was repeated of returning back the case diary and to be procured again. Thereafter, on 2/5/2025, on 2/5/25, the petitioner, the case diary was not received and the petitioner was granted interim bail with conditions. When did it come last? Last year, Banaji, last. No, 2/5/25. It was returned back. No, same exercise was repeated on that date, that way to date. 23/1. I think 23/1. 23/1. Thereafter it has not come. I think thereafter it has not come. 23/1. After that it has not come. Since 23/1 it has not come. He has forgotten about it since. Interim bail लिख लेना. Thereafter it has not come. Since then, several dates have elapsed. And case diary has not been received. And interim bail granted earlier has been directed to be continued on each such dates.
17 days.
No, after it went back for the last time.
23/1/25, my
Yes,
lord.
from you calculate from there.
After 23/1, my lord, 1, 2, 3, 4,
can
5,
help me.
6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Today is a 16th date.
After the last time, after 23/1/2025, when the CD was received and directed to be returned and procured again for the next day, along with updated investigation and FSL. About 17 dates have elapsed till date.
Today is 16th day, my lord.
Also
Yeah.
heard, 16 dates have elapsed, including today. Anticipatory bail application cannot be kept pending for such a long time. I see no reason why case diary call for cannot be sent by the investigating officer. Full stop. The court has not even asked for any detailed report or not even a status report. Full stop. All that the IO has to do is, send the case diary along with a messenger, through a messenger of the department. Stop. Which Thana? Which Thana? Full stop. Issue a fresh reminder for the case. Issue a fresh reminder for the case diary to be sent with updated investigation till updated investigation till date, along with the FSL report. Further, let's give that only, like I have given earlier, no? Mr. Goswami.
Lordship.
Let him submit a written report also this time. The IO cell also submit a written explanation as to why the case has been why the IO has not why the case diary has not been received despite the elapse of so many dates, keeping the bail application pending. Good stuff. Thana is which Thana? Golaghat. A copy of this order shall also be sent to the OC of Golaghat Police for information and the needful. The case diary along with the other case diary shall be positively sent on the next day, failing which the court will be constrained to take exception.
And my lord,
List after vacation. List.
after vacation, my lord. Interim may continue, my lord, after vacation.
Interim
my
has to continue.
Yes.
Interim bail passed on 2/5/25 stands extended till the next date of list. Yes.
My lord,
Any other thing?
I pray, my lord, there has to be a direction, my lord, from the court that each time a case is fixed for production of the case diary, either case diary or the said report which has been called for, like FSL, postmortem, whatever, either that should reach the court or a written explanation should reach the court.
That is there, always there.
My lord, but it is not followed, my lord.
This is not being followed.
That direction may be passed, my lord, and order may be circulated, my lord, through the Director General of Police, my lord. That has to be there, my lord.
Let us see on the next date, maybe.
Because, my lord, this case is a classic example, my lord, how an anticipatory bail application comes up for 22 days before the High
I've
Court.
seen this. I've seen
7/1/26.
7/1.
Obliged, one.
30.
Additional PP you also instruct, huh?
Yes.
Instruct them strictly.
So copy of the order furnished to me.
Okay. A copy of this order shall also be furnished to the learned additional people. Okay. This matter you had mentioned in the morning.
Yes. Interim was there.
Yes.
It can be disposed of.
Yes. Interim bail was granted.
Granted, yeah. Their appearance, flexion also.
Allegations are very bad. Look at, as per the allegations, very, very bad allegations. No, as per the allegations, he marries this woman, inflicts cruelty upon her,
Yes.
you know, physical and mental. Then she discovers that he's already married
Married person.
to another lady who's HIV positive. And then he's a government servant. What was the mention? Can you repeat? I forgot in the morning.
Seeking adjournment.
Seeking adjournment.
Adjournment.
Yes.
Can we dispose it of before vacation? Your senior,
My senior is not available.
who is he?
S. Munir.
Munir.
Immediately after vacation. But
Immediately after vacation. Diary you will send back. Hmm?
And investigation is sufficiently progress. If you can retain it, then investigation is sufficiently progress. If you can retain it, the statement also recorded. They are on interim.
I can dispose also, but suppose it goes against, then she should be given an opportunity. Very bad allegations. No? I mean, these things are true. Forget law, human models. Forget law.
Immediately after reopening.
6-1, okay. And Begum, learned counsel, submits that the leading counsel, Mr. Munir, is unavailable. It's 2 days, and prays for fixing the matter immediately after vacation. The case diary has been received, and this stated to be sufficient progress in investigation also, as contended by the learned additional PP. You can retain it perhaps. Would you like to, will it be hampered? Last is statutory period, all these things might be there.
It's in all our anticipatory bail.
Also, then it's okay, you retain it then. Stuff. The case diary be retained for the next step. Interim order passed earlier.
7th.
Passed by order dated, so and so. Yes, you know the date. 7/4/2025. Stands extended till the next date of listing. 6-1 or 7? 6-1? Okay.
Obliged.
31.
May please, madam. The petitioner is an interim. The PCR thing received. But the case diary part was not written in the PCR also.
As per record, there is no charge sheet was submitted, my lord, but the learned to be submitted earlier did the charge sheet was submitted. My lord, in the LCR, my lord, there is no charge sheet, my lord.
About 13/27.
Girl has been recovered, most probably.
That, my lord, my interim was granted after perusal of the CD, my lord.
Only thing was that on that day, my lord, there was no 183 statement was there, even 181 statement also not there available in the CD, my lord. But the honorable court presumed that, my lord, 183 statement was recorded, but not in the cash diary. Actually, my lord, as I perused the, my lord, record, my lord, there is no 83 statement, my lord. 83 statement might be not recorded, my lord. Even there is there is an order also, my lord, where it is categorically passed by the learned citizen that no statement was recorded under section 183, my lord.
The CD part and first sheet copy is still also annexed in the TCR also.
Otherwise, this is the second occasion of this girl, this allowed with this petitioner, my lord. Earlier also allowed, my lord, when she was minor, my lord. Presently, she is major, my lord. And subsequently returned, my lord. After returning, then the informant lost this affair.
Oh, he's 45 years and he's a.
My have no submission before lordship that issue reminder for issue along with the case diary lordship. Because petitioner is an interim lordship.
Achha. 164 is not there, statement is not there.
No, my statement not recorded.
Oh,
my
not recorded.
lord. Not recorded, my lord.
Entire case diary part is not there.
I see. Yes.
Even, my lord, there is an order, my lord. Order dated 13/3/2025, my lord. What should be perused that order, my lord? It will be clear, my lord.
13/3.
13/3/2025 for the LCR, my lord.
Yes.
TCR.
The 13/3, I think you are mistaken because 14/5 is the first order, earliest order, 14/5, then 21/5. Then 13/6.
Order dated
13/6.
13/3, my lord. Of TCR, my lord. The order, my lord.
Was it the TCR?
Yes.
Yes.
But where it is observed that, my lord, 183 statement not recorded, man.
13/3 FIR was on 1/3.
Mhm.
1/3/25. Wait.
There is no other order. Where it is that the 183 statement was recorded, man.
So 13/3 is the initial part also. The later part also, it
Yes.
may be 183 statement be there.
But there is no such order, my lord.
The though scan record is available, but it does not contain the scan case diary. The case has already been charged sheet. The petitioner is on interim bail by order dated 21 or 14?
21/5.
Oh, yes. 21/5/2025. Good stuff.
Even, my lord, that order also passed after perusal of the CD, my lord.
Allowing the prayer of the learned additional PP in this regard, issue a requisition for the remaining part of the record, remaining part of the case record, scan form, including the case diary.
Along with the
Yes,
charge sheet also.
A case diary and charge sheet. Or should we get only the case diary and charge sheet?
Record is there, only going to the
Yes,
SCP table.
is it right like that? Issue requisition for scan copy of the case diary and charge sheet. Case diary and charge sheet. Of Bhuragaon PS case number 13 of 2025. Okay. Interim bail stands extended till the next date of listing. This is the matter on. Then suggested it.
26.
You can a little later also maybe.
After Bihu, I guess, no.
After BU also. 21.
21 or 20.
21/1.
Acknowledgement.
32.
32 also, lordship, we have CD was earlier received, lordship, but up to that CD was called for, it is not received. It's not an interim. Just from Bilasipara.
Case diary is not received. Issue reminder. Stop. Interim bail granted by the order dated 1/8/25 stands extended till the next date of listing. List on
26.
7/1/26. Might go about 26 over 25 over. That's right. Hold on.
Production list item number 1.
Would you like mention?
Maybe. I already mentioned morning. Here in the case between the husband and wife, they are living separately for about 12 years. Now, the wife, they have got a minor child also, total. They have filed a petition under section 120 and maintain current 7,000. Then they have filed an inheritance petition before the principal Jar Miller, and there was inheritance Miller to the rupees for 2,24,000, and I am paying the same Miller. Now the Miller wife has filed a petition on 12/25 Miller, praying that her daughter is suffering from silence, so Miller rupees 3,66 square. And the learned Miller, principal Jar Miller on the same date immediately issued Miller rupees, issued direction to the petitioner to pay rupees Miller 2 lakhs. And the petitioner Miller is a constable Miller, and his salary is about rupees 65,000. And 24,000 is giving Miller for a maintenance, and Miller he has a loan Miller and his maintenance supply. Now Miller, my submission will also be
Let me read the impugn order is 12/12.
my lord.
I'll just go through it once, huh?
My lord.
What direction was it?
And I said 2 Miller.
Ex parte order was passed.
Expert immediately on the same date, yes.
Some circumstances. Okay, next.
Next Miller, my submission will is the I am ready to pay Miller any Miller medical treatment to her, my daughter also Miller. To Miller, those medical facilities are available at Barpata Medical College and also into GMC. And Miller, I am seeing Miller Indian Medical College institute is here in Miller and also GNR. And Miller, similar petition Miller earlier filed by her Miller before this also there, and I filed a revision here Miller.
Many people go to Chennai also for better treatment. Anyway, subject to their
But
affordability.
They have to have
Affordability, whatever, you know.
Well, that Yellow can see earlier order Miller. Yellow can.
Yes.
Like-
She appears to be suffering from carcinoma, cancer.
No, there is not cancer. Miller, except that
Lymphoma,
but there is my inspection is that may not be cancer. First,
that is why they have rushed.
that may be yes.
That is why they have rushed.
there
Because
may
it has
be-
to be operated immediately
yes, and that may be true.
and biopsy done.
And similar petition Miller by her Miller against me and against the your lordship the honorable passed order directing that to make a treatment at Barpata College, and if there is not there Miller, then any other place in Assam or GMCs or GNR Miller. Or Miller AIMS is also there Miller here in Guwahati. So, and I should have that capacity. I am a constable. I am earning only 55,000 per month.
55,000.
55,000 and 4,000 for maintenance to them Miller.
You are paying 24,000.
25,000. And I have some loan, about 20,000 I have loan. I have given my bank account.
Don't you want to give the best treatment possible within your financial limits to your daughter?
Exactly.
To your daughter.
First, Miller,
She's facing a life-threatening condition almost.
let go, Miller, GNRC or GMC do that. And if there is not there, then I definitely Miller, I will try Miller with my capacity. And no doctor says Miller, she should go to the outside the state Miller. They are Miller.
That is not a very fair, kind submission, you know, for your own daughter. You know. She is facing that emergency surgery is necessary to remove that thing and subject it to biopsy. to
And
confirm.
biopsy also not.
Because if it grows, then
Then it will be intensity. But no biopsy done till then. And suggestion is there, my lord.
see, this is not a question of this thing. Of course, now it will be admitted, but if you want stay, you pay half, 1 lakh you pay.
No,
Why
my
don't
lord,
you?
my prayer will also is
You're
there.
getting salary of 50,000, isn't it? You have some savings. It's not for a luxury. If it was for some other, some performing some wedding or something, I would have, as such, I discourage it for this for
Then
too much of
but
expenditure. But this is there was some, that's why the learned judge was not completely off the mark actually. So because of the urgency, he has, this thing. Maybe we can,
Now let only my submission will also is there. Let her be treated. My first may check here properly. Then let her go, my lord. I have no objection with that.
that is,
Within a week, my lord, it will be completed. Examination of her, my lord, will be completed. Or GNRC or GNS. Then you know.
too much expenditure this nowadays. Most of us cannot afford all these things. But anyway,
From birth,
still people go because they have hopes, to survive.
From birth, my lord, she is, my lord, severed from me. I am also separate. No relation with her.
Yes, that's unfortunate to me.
And very assume. As her mother, my lord, the opposite party here, my lord, he is the wife. He is not agreed to decide with me, my lord, and to do all necessary work. My item, my lord, still granted, and if you lordship saying 50%.
Mother, what is the mother doing? She's a housewife or something.
House and my lord. And nothing.
She's studying in a good school. Daughter is studying in a
Yes.
Royal Global.
God is not here, my lord. There is the other school is there.
Oh,
In Kolkata, Kolgasia. She has a hard, my lord. Believe it. Don Bosco, they are in Bokol, so
Yes,
in Bosco.
Heard
Immediately.
Roshit, learned counsel for the petitioner. Good stuff. Invoking the powers under 438, 442 BNSS. The petitioner Safiqul Islam was stated to be the husband of the sole respondent Mamoni Khatun is aggrieved by the order dated 12/12/2025 passed in FC criminal case number 35 passed by the learned family principal judge family court Barpeta in FC criminal case number 35/25 whereby the petitioner was directed to pay rupees 2 lakhs to the respondent within 17/12/2025 towards the treatment of the daughter of the parties.
Mamuni, Farhana Begum.
No need. You have a petition where she sought this, no?
No.
Oh, yeah, I got it. Got it.
Yes, that is Milan Annexer 2. Yes.
The respondent have filed a petition before the learned family court. What was the miscase number? It was a miscase?
Miscase, Milan, there is no miscase. Earlier miscase was here, Milan.
Oh, sorry.
Main case was Milan,
Oh,
FC
sorry.
criminal 35.
Petition, which was
2015.
taken up in the disposed of FC criminal case number. It was a disposed of matter.
Misuse of Milan.
35/2015. In the said petition, the respondent contended that the daughter of the parties is having a health condition which necessitates surgery and for which she contacted Apollo Hospital, Chennai. And after discussion, it came to be known that expenditure would be in the range of rupees 3 to 4 lakhs. He stated that she was not having source of income and and desperately needing the money. She contacted the petitioner, who is the father of the girl, to seeking some money from him. Full stop. It is she has contended in the petition that the petitioner is a government job holder, along as well as owner of landed properties earning rupees 2 lakhs. The aforesaid impugned order was passed by the learned Principal Judge, Family Court, on ex parte basis, perhaps considering the exigency of the medical condition. Since the petitioner is seeking adjudication of his grievance, the instant criminal revision petition is admitted. Not admitted, it's issue notice. It issue notice upon the respondent, not admit, it will remain at admission stage. Issue notice upon the respondent, call for the scan copy of the relevant case record pertaining to FC criminal case number 35 of 25 from the learned Principal Judge, Family Court. Full stop. It is submitted by the Borpeta, sir. It is submitted by the Mr. Rashid, learned counsel for the petitioner, submits that he's willing to bear the expenses of the medical expenses of his daughter, but that he can take treatment in the medical college at Borpeta as well as the medical institutions available in Guwahati. The medical circumstances and the exigency projected from the side of the respondent giving rise to the impugned order cannot be brushed aside completely. At the same time, it has to be also kept in mind that the order was passed ex parte. You pay 1 lakh, that will be okay for you, for your daughter. Let her take treatment wherever. Goal is that she should get well. Get rid of this. Whatever is there, it should be, because
Examine here, then let them give. Without examining
for your daughter, I will not say anything. Chennai, well, that's not for me to say. I'm not a doctor, nor you. So it's for them. It's a medical advice. So she should have some money in hand. That's all. Otherwise, also you help her. You are paying also. Yes, this must be recorded. It is submitted by the petitioner counsel. I got that. In terms of the order of family code earlier, he's already paying rupees 24,000 per month towards maintenance of the respondent / wife and the daughter. Full stop. Till the next, in the given facts and circumstances, till the next date of listing, full stop, the impugned order that it's so and so past expert 12/12/25 shall remain state. Subject, however, to the condition that considering the projected medical exigency, the petitioner shall pay rupees 1 lakh to the respondent for the treatment of their daughter, for the immediate treatment of their daughter. That's all. At least you are having some means, right? So many people are not even fortunate to have this much means, 50,000. So I will fix a longer date, last week of January.
Oh, sorry,
When
yes.
should I fix it? You should notice you will be taking steps, right?
I'll take step by tomorrow.
Last week of January. That will be best.
29.
Oh, yes, 29, 30, 29/1.
My lord.
I'm keeping, you want this back?
No, you should make it.
You want, take it back?
My lord,
You can give me again,
Yes.
if necessary. Give the court, whoever the court.
33.
Okay.
Charge sheet submit করছো My lord, we are already on the interim.
Yes. Same. Boundary dispute. Diary
That was substantive.
or just it's
Substantive.
no serious injuries, I think, isn't it? Or caused injury, sharp weapons. Any idea? No. Otherwise, we can dispose it of, making it absolute. আগৰ অৰ্ডাৰটোৰ পৰা লৈ ল'ম হা তো আমাৰ নহয় কিন্তু অৰ্ডাৰটো 26/8/2025 26/8/25 you Mr.
GK Gogoi.
GK Gogoi, heard GK Gogoi and DP Goswami learned additional PC. That's a para 2 and 3 are same. It is submitted that the quarrel arose out of some boundary dispute between the families and that all the persons are relatives. The petitioners, more than one,
Yes, for
four petitioners, four petitioners. Petitioners were granted interim bail on 26/8/2025. The learned additional PP submits that the case has been charge sheeted upon completion of investigation in the meantime. In view of the same, the interim bail by order dated is hereby made absolute, subject to the condition that they shall be available for trial if one commences. They shall not hamper or temper defense. The bail petition stands allowed in this post.
Rajman.
24.
The total of the same pairs are six subject.
I appeared, my lord, after getting into my statement has been recorded, my lord.
Itu আমি এনেকে মাৰি দিম খালি মই আপোনাক দেখাই দিছো অৰ্ডাৰটো relevant order. Let's the petitioner এনেকে লিখো the petitioner was Mr. Abdullah and DP Goswami. The petitioner is seeking anticipatory bail in connection with Bokhisto PS case number 472/25 under so section. What was the allegation?
But allegation, there was a scuffle in the college. my lord.
Scuffle. Scuffle.
In the college premises among the boys, my lord. But he appeared, man. This statement has been recorded. That may be the lordship may record my statement, man.
The petition, one petitioner?
One petition.
The petitioner was granted interim bail on 22/9/2025, pursuant to which he is stated to have appeared for the IO and statement recorded. The any confirmation regarding? You don't have anything regarding his appearance. You don't.
I when it is
Yes,
recorded.
yes, no issue, no problem. The but you make it the additional PP submits that cash sheet submit in the meantime.
25.
Right, CS number
521/25.
531 of 2025.
Dated 8/12/25.
Any section? No.
No. Actually, it's not.
No.
Then you can perhaps sometimes give them that direction that take take a little more trouble and write the sections. It will be very helpful for us sometimes, isn't it? When they send the intimation, they can write the section. It will help us, help you, and help the defense also. They may have other knowledge, but still, they are made subject to the same conditions, trial, and have not hampered temporary defense. Bill petition stands allowed and disposed.
Applies, my lord.
25.
You have to give. That please your lordship. Okay, that's it. Oh. Is it easy?
My lord, this is the cross case also there, my lord. I am in interim, my lord. I have appeared before the IO, my lord, on 27th of September. And what are the, my lord,
This is in which you are seeking bail, that is 193.
193, my lord. 194, my lord, already
Charge sheeted.
charged. That affair has been lodged by us. My lord.
Yes.
Told me.
1610 or
Wait, no, my lord, up to that case there is not come. Last occasion it was called for, my lord, along with the TCR scan copy. Scan copy has come, my lord. This is a very old case there, my lord. In this regard, one case has already been decided. My lord, kindly for your lordship perusal, my lord. My lord, kindly turn to page 40, my lord.
40 of your petition?
Yes, my lord.
Yes.
My lord, I am reading the operating portion, my lord. That is the one who, what happened, my lord, one of the family member of the present accused petitioner, my lord. He was called by the police IO, my lord, and accordingly he has been arrested. While he has filed a bail application, at the time of the allowing the bail application, my lord, the additional session judge of the Dibrugarh has observed, kindly turn to page 41, para 5, my lord. In the bottom, my lord. I have perused the case record and case diary. On careful consideration, the following observations are noted. The accused has been custody since so and so, and there has been no substantial progress in the investigation post his arrest. The investigating officer appears to have already examined most of the listed witnesses, thereby diminishing the possibility of tampering with the evidence or influencing the witnesses. Considering, my lord, that means, my lord, already they are concluding the investigation, my lord. Therefore, my lord, in this stage, my lord, up to the case that your last occasion call for, my lord. I am in interim, my lord. I appeared before the IO. Very interestingly, my lord, I have appeared before the IO twice, my lord. On 27 and 29, my lord. Both the time, my lord, our statement has not been recorded by the IO. But the IO told us that in our case, my lord, the statement has already been recorded. Therefore, my lord, it is not required for record our statement. I have accordingly, my lord, in this regard, I have submitted an application before the Superintendent of Police, Dibrugarh, by this application, my lord.
You want me to say? I'll see.
Yes, my lord, up to that case,
No, I can see it if you want me to see.
And then the request to the police, Superintendent of Police to make a direction to record our statement. Still that, my lord, no action has been taken.
No.
So my extension order has been submitted before the IO. That is also acknowledged.
Okay. Can I keep it in the?
Yes, lordship.
Darius, come.
Diary, my lord, that is, my lord, on the motion day when the matter first came on 22/10/2025, my lord. On that day, my lord was pleased to, my lord, run interim, my lord. Now, my lord, thereafter we received the CD, my lord. Now, my lord, they have to take back the CD because, my lord, my learned friend, my lord, draw the attention of this honorable court. There is the order dated 6/9/2025.
Yes.
As per that order. Now, my lord, the CD available with us, that is he is, my lord, giving attention to the order that is 6/9/2025 and the diary entry available with us up to 25/9/2025. Meaning thereby, my lord, though my
Few
lord,
days only.
that is, my lord, updated case diary. If, my lord, we are going by that 6/9/2025 order. And as per that, my lord, if we go by that, then, my lord, this is, we can take it as updated case diary because it is available after 6/9/25, my lord. And, my lord, the sufficient materials are there. Not only, my lord, that is the FIR name people. And another one.
Injuries are there? Injuries?
Injuries are there, my lord. There is grievous injuries, my lord. I have flag marked all the relevant portions, my lord. And, my lord, not only that, my lord, that is the neighbor. One neighbor is also, my lord, he is also injured. No, obviously, it is a simple
What
injury.
happened actually? The allegation was, let us go back to the original FIR.
Page 12, my lord. I am coming to that question, my lord.
Page 12. I'll read it.
That is their FIR, my lord.
Yes,
Allegation is very much serious. Now, both side allegation is
both
very
sides allegations are serious. Kanaya Prasad.
Yes,
The informant against who was filed against you.
against me. That is a
We have called for this case diary only. One case.
My lord, case diary was called for, my lord.
And
discussing
TCR
about.
in that case, my lord.
My lord,
My lord, TCR is not received. My lord, there is a one cross case is there. This is my lord, the case diary of.
Why was
190
TCR called investigation?
TCR is called for because my lord, they also filed one, my lord, Ajaha. In that case, my lord, that is my lord,
Investigation.
search sheeted.
I see. Investigation here is not completed.
It is not completed, my lord. 193 not completed, 194 already completed,
sheet.
search sheet submitted. But my lord, maybe my lord, they call the requisitions of the TCR only, not the including the case diary, my lord. Though my lord had reflected in the order, my lord, that is the TCR. Only my lord, order sheets are available with us, my lord.
What is we discussing?
No, no, at the time, the motion of data call position. Both are TCR. Both are TCR.
TCR to अपना
Sir.
order sheet খিনি পঠিয়ে দিছে।
Only order sheet.
মানে যেখিনি হেৰি available আছে।
একো দিয়া নাই
CD পাৰ্টটোৱে পঠাও।
একোৱে পঠোৱা নাই
CD নাই, চাৰ্জেট নাই, একো পঠোৱাই নাই। তেওঁলোকে অকল TCR বুলি ক'লে তেওঁলোকে ভাবিলে এইটো পঠিয়াব লাগিব। এইটো হয় most of the case। ঠিক আছে। এনেও যদি এইটো যদি dispose of কৰে 25 নাই আমাৰ লগত আছে। তেতিয়াহ'লে ঘূৰাই পঠাব লাগে। We will update it। এইটো আহি যাওক। সেইটো কৰি লওক। আপোনাৰ vacation এটা time লৈ লৈছে।
In the next election, my lord, that is our affair, my lord.
Mhm.
Basically,
Lodged by Sarita Devi.
Sarita Devi. My lord, medical certificate, I have annexed
Oh,
all the medical certificates. And we were admitted by the police in the hospital, my lord. The name accused also there, my lord. The petitioner, present petitioner also is there.
That means market, mutual market.
Yes, my lord.
One could be, but there are injuries on this side. No?
Previous injuries.
My lord,
Previous
we are very much serious. My lord, we have to admit it for 1 month, my lord. Sarita Devi and her husband and the petitioner number 1, my lord. I have annexed, my lord. Sagar Mahato, my lord, lordship will find the page 32, the medical report.
I think CS
Yes, there are documents may be.
scan record was rightly called for. But here we don't have much materials. Only the charge sheet would have done. Filing the charge sheet would have, only the copy of the charge sheet of the cross case would have helped. Even that was there, it was helped. Otherwise, we'll have to go from there here only. We have to go by here, this CD only.
My lord.
Mike, in the
Yeah.
in the my case, my lord, whatever they entered in my premises, our premises, they broken up our vehicle, my lord. And my lord, after that, my lord, nothing has been done by the police authority and search has been given. And we were admitted by the police before in the hospital, my lord, from the spot. It is clearly stated in my affair, my lord. Lordship will find at page 16, my lord, the
What to
police
do?
officer hospitalized us in AMC Dibrugarh. And my lord, medical report, lordship will find from page 30 and 18, my lord, annex 3 series, my lord. So many occasions, my lord, so many tests was done in respect of the father, husband of the petitioner. Okay, my father of the petitioner, mother of the petitioner, and the petitioner number 1 also, my lord. Already, my lord, so many witness has been examined. As per law.
Lot of injuries, not, there was bitten on kidney also. This is
Well,
a-
my lord, there are Caesar witnesses. Those who are, my lord, that is independent witnesses, they, my lord, their statements are there. And my lord, one neighbor, my lord, who also lodged another FIR, my lord. His injury is simple, my lord. That is also I have flag mark, my lord. সেইখনৰ লগতে একেটা হেৰিত আছে কাৰণে তেওঁলোকে বেলেগকৈ ৰেজিষ্টাৰ কৰা থাকে। One neighbor.
But this injury has been categorized as simple injury. This injury particularly.
It's simple, my lord.
One is
Other
simple.
two, my lord, I have flag
Ah,
mark only grievous.
Others
part,
are
my
not.
lord. Yes, my lord.
Others
Others
are
are grievous. Only grievous injuries part, my lord, I have flag mark. They use the hockey stick like my lord.
On the, yes, written on the stomach with hockey stick according to
My lord,
allegation.
intention is very clear, my lord. Not just a scuffle, my lord.
Both side, my lord. Intention is very much serious.
Massive market. I don't know. Very violent activities.
My lord, the incident has taken place in the month of June, my lord. Now, one case has been, the date has been given to appeal in our case. At this stage, my lord, since court has observed it on a very early stage, all witnesses have been examined. There is no any. I am in frame, my lord. I appeared before the IO, my lord. In our case, my lord, our statement has been recorded, my lord.
You think custodial interrogation will be necessary?
My lord, the nature, my lord, the nature of the case.
Yes.
Otherwise, my lord, this is the heat of a moment, my lord.
Hero,
Somebody, my
that's
lord,
true.
but
Very violent.
very violent.
These are
And my lord, not only they, both the my lord groups, my lord. Apart from that, my lord, there's a neighbor is also affected, my lord. There's a one, my lord, he filed an azahar, but my lord, that is they kept is a part of this case only, my lord. That is also I tag my. His injury is no doubt, my lord, simple, my lord, simple in the sir.
Who's?
My lord, one, my lord, Han, my lord.
Huh.
Yes, my lord. He is not, my lord, the party to this case, my lord. He's a
Some others
neighbor,
have suffered grievous
Yes, my
injuries.
and he clearly implicates.
It will be better to see the up-to-date case diary, my lord. Since we are actually,
That only. It is not up to date.
it is not up to date, my lord.
Up to this one, not up to up to 25 lakhs, and that order, my lord, is 8 lakhs. If we go by
That order, my lord, that is my contention of the court at the early stage.
6-9, my lord, that is reflecting Annexure 5, my lord, page 40, my lord. If we go by that, my lord, then it is 25-9, it is the updated CD, my lord.
No, my lord, I have, the case diary was called by your lordship on 22-9, my lord.
Yes.
Lordship called the case diary on 22-9, and last occasion also lordship called the case diary, my lord.
Stop me and I can go. Huh. Or Bora, Debe, and K. Bushop. Learned additional people. Hmm. 22-9, 2025, 22-9, 2025, para 2 and 3 you take. Para 2 and 3. It is submitted by the petitioner that with regard to the same incident, FIR was filed FIR was filed by Sarita Devi, which resulted, which was registered into Dibrugarh PS case number 194 of 2025. And the said case has already been charge sheeted by its CS number 210 of 2025. And the same is also reflected in the last order dated 2/12/2025. It is submitted by the petitioner counsel that pursuant to grant of interim, they have appeared before the IO and their statements have been recorded. The learned additional PP opposing the bail submits on the basis of the case diary that the investigation has sufficiently incriminated the petitioners and the medical/injury reports of the victims are also available. Full stop. And 2 of the victims have suffered grievous injuries. Full stop. I have perused the state medical reports. It indicates hematoma, HAEMATOMA, hematoma, collection of blood. That means this is comma. There is indication of assault in the area around the kidney with leading to injuries which were detected medically. Stop. With regard to victim Kanhaya Prasad, the medical report indicates fracture in the neck area and also fracture in the metacarpal area of hand. And the injuries have been categorized as grievous. Full stop. So it is submitted by the learned additional PP that the statements of witnesses have also implicated, besides the statement of the informant who has supported the allegations. So, prima facie, it appears to be a case of mutual marpit between the parties. The learned petitioner counsel submits that members of their family also suffered serious injuries. So,
That is medical reports. All of the medical
there is
documents.
in the case diary, there is a noting regarding the injured victims and mentioning that mentioning injury report of 5 victims were collected and indicating grievous injury on 2 victims and simple injury on the other. On the materials, it is clear that the from the investigation, from the investigation materials, it appears that there were significant assaults by the petitioner side and leading to injuries to as many as 5 persons, with 2 of them suffering from grievous injuries, some of which has already been described above. Full stop. Though the petitioners have appeared before the IO on the statement recorded, but investigation is still in progress, and considering the serious nature of the materials revealed, full stop, I am of the considered opinion that no fetters should be imposed on the remaining investigation, and that this may not be an appropriate case for anticipatory bail. In such view of the matter, the interim bail is vacated and the instant anticipatory bail stands rejected at this case. Return back the case there.
At least this, my lord. Actually, what happened, my lord, in this case, my lord, our statement has been recorded. Everything has done, my lord. Lordship has, at the time of the granting the bail.
No, because at that time we do not know. Preliminary view is taken. All these materials come before the court.
My lord, that is on June, my lord. This is the December, my lord. The entire incident. At this stage, my lord, this may be.
Not the fifth case.
36. In this matter, Lordship, FR has been submitted on 12/12.
Initially, it was not clear. Then we got a report.
Lordship.
Got a report.
Later on, it is filed and FIR was registered. And then after during the
Gormur PS.
Gormur PS, Mr. Fazul.
Sure. Diary has come.
My lord, who is an interim, my lord, so we wait for a my lord. product.
FR has been submitted.
FR submit.
FR number is 3 of 2025.
But that communication, my lord, we don't have, my lord.
There must be through. So
Yes,
let him get the confirmation official from that side. But I'll record your permission. The petitioner was granted interim bail by the order dated. Order dated 17/10/2025. You appeared, no? Statement was
Yes,
recorded.
on
Person to
the
which is
same
stated
day
to have appeared
appeared.
on the same day. The statement was recorded. Full stop. The learned counsel submits that in the meantime, upon completion of investigation, final report has been submitted in the case. File FR number
Right, FR number
I can
3
record.
of 2025.
3 of 2020-25. The case diary, however, has not been received, and learned additional people seek some time to confirm regarding the final report. Prayer is allowed. The interim bail right order dated 17/10 stands extended till the next date of listing. Immediately after reopening, you'll dispose it of.
Sir, view vacation, Lordship.
After view.
View vacation. Lordship, I
22-1.
want to submit one more thing that the Gormur PS later on the FI was registered as Gormur PS case number 49.
45 or 49?
49.
Oh, I've written wrongly then.
Oh, 49 of
GD entry is 17.
GD entry 70.
Yes, my lord, this is 49. That information we have, my lord, because we have a communications, my lord,
First of-
28/11.
Petitioner had
25, my lord.
filed the instant petition. What লিখি দিব ওপৰত? In connection with Gormur PS case number 49 of 25
25.
within bracket pertaining to Gormur PS GD number 17 of 25 dated 13/10/2020.
Deeply applied.
Let may be fixed, my lord.
That may fix.
No, I did not give date.
My lord.
22/1.
22.
Is it okay?
My lord.
22/1. Right.
My lord.
Lordship.
May I please? My lord, interim was granted, my lord, and the due was called for.
That is CD not received, my lord.
My lord, in this case, my lord, I have information, my lord, with number, specific number and date, my lord, it is charge sheeted, my lord.
Charge sheet.
Yes, my lord, charge sheet number 135 of 2025 dated 5/10/2025.
Similar about what I'm saying. লিখি দেব। The case, the
the
petitioner was
late-
granted interim bail by the order dated 24/10/25. He has appeared,
Appeared, my lord.
pursuant to which he is stated to have appeared
No, my lord,
before the IO,
may I clarify, my lord, when appeared she, my lord,
but not recorded.
no, my lord, it was found that it is already charge sheeted, my lord.
I see, I see. And then no need to write. He was granted interim bail on, so will not write anything. Full stop. Mr. Borbia, learned counsel, submits that as per his information, the investigation is already completed, resulting in a charge sheet, right? CS number
135 of 2025 dated 5/10/2025.
Mr. Boysa, learned additional PP. Seek some time to confirm the information from the police. Full stop. Case diary is not received today. Stop. The interim bail stands extended till the next date of listing. List on same date, should I give it? 22/1. 22/1 after you. No?
42.
Meet this a lot. No, this is second anticipated bail application, my lord.
No.
The FIR, my lord, is at page number 13. The allegation was that, my lord, an eviction drive was carried out in Python Reserve Forest.
Second bail application. Diary has come.
Yes, sir. I received, my lord.
Page number 18. Up to the person.
He suffered bullet injuries.
He suffered bullet injury, my lord, but no.
Now he has recovered.
He has recovered after, my lord,
Not
he
fully.
was in hospital for around 2 months, my lord.
I see.
And his statement was also recorded in the meantime. So, my lord, basically, it's a petition seeking mercy, my lord, because he already lost his house. He got injuries, my lord, and my lord, the injury, most importantly, was from the backside.
Mhm.
It primarily shows that, my lord, he was not charging at the police.
Mhm.
And there was, my lord, blanket firing from the police person in my lord. Because around, as per the FIR, around 400 to 500 people were obstructing the district administration. So perhaps he received injuries, my lord, and no specific role has been, my lord, attributed against the petitioner. Just because he received injury, my lord, he was admitted to the hospital.
Hospital.
Yes. And FIR, my lord, is of 18/7. So near about, my lord, 52 days.
24/10, it was last rejected.
Last rejected.
Yes,
my
my
lord.
lord.
It has progressed, maybe we can call.
Yes.
Since he is also a patient, he suffered bullet injuries.
Yes.
Whatever it is. At that time, I accepted the prosecution's contention.
Yes,
that Investigation was in progress, so
my lord.
active progress.
My lord, 24.
Voluminous investigation.
Yes, my lord, not, my lord, because, my lord, here only, my lord, only relevant part, only, my lord, two, my lord, because after 24/10, because the rest part, my lord, the case and allegation is that, my lord, they not only obstruct, my lord, they tried to take the firearms and all, my lord.
Yes, that is why actually
Yes,
the
yes.
anticipatory was, I
I
was hesitant about giving.
Only two green flag marks, my lord.
Because FIR shows 400, 500 person.
Yes. Group things are always very risky.
Yes.
You know, the
Yes.
risk of false implication is
Yes.
always there. Which one should I see? Note.
My lord, only
Note.
two green, yes, one note and one green flag mark, my lord, regarding that. from the senior superintendent of police, my lord, regarding some expert opinion that his name is very clearly they stated, my lord, along with others.
Kosimuddin, no? He's Kosimuddin.
Kosimuddin.
He could not be found. Yes, yes.
They tried, my lord, after that, my lord, and my lord, another.
But he's on interim bail. Sorry,
no,
he's not on. Sir. They have been looking for him.
One
Yes.
casualty
That is why he has
there, my
come.
lord, others were, my lord.
After this is the only investigation after 20.
Yes, my lord. And one, my lord, that is another green flag mark is there, my lord. That is a, from the expert opinion part from the SSP, my lord. Article, my lord, article it is. Yes, my lord, that green flag, my lord.
Superintendent the police. This one.
Yes.
They are collecting a lot of this kind of ballistic evidence also.
My lord, my lord.
Seems.
And his name, my lord, along with that, my lord, he is part of that move, my lord. That is, my lord, clearly, my lord, that is indicated, my lord, along with others, my lord. One casualty was there, my lord, that point of time. Otherwise, my lord, race part, my lord, that is the already, my lord, has gone through that, my lord.
Yes.
Those parts are there.
You're right. Strictly speaking, anticipatory is slightly problematic in these matters, but anyway, he since he suffered some injuries also. So
Because
maybe,
And his statement has already been recorded.
yes.
And my lord, the same way, my lord, that is the, my lord, lot of, my lord, that is to tell, my lord, injured police personnel and my lord, that is.
Lot
the-
of people.
Yes, my lord, 20 numbers of, my lord.
Mm.
They got injured, my lord. That is the injured forest personnel 11.
Yes, because there was a
Very injured.
serious law and order incident.
We are not denying that, man. We are not denying that.
But my lord, if my lord go through the, my lord, there is a witnesses, my lord. They taken all these things, mics and all, everything, my lord. They giving the alert. After that, my lord, this situation, my lord. They tried to even, my lord, snatch the firearm and all.
Definitely, my lord, if people lose their homes, my lord, and there was also FIR indicates that there was instigation from third party, my lord. FIR itself shows that, my lord. There was instigation. So,
My
definitely,
lord,
my
at
lord,
this stage, my lord, because my lord, police is searching him, my lord. That notice, my lord, available. my lord.
police, my lord, have recorded the statement.
Already, once it was recorded. His statement must be
He
here.
was under treatment,
Didn't notice
under the
his statement.
supervision of police, my lord.
I have already gone through. You can take
Yes.
it. You can
Police had admitted him in the hospital.
recorded in statement
Yes.
at that time. You must be there. You can have a look if you want. It was our subsequent petition. AB. This is a subsequent bail application, as an earlier bail application on behalf of the accused was rejected on 24/10/2025 in AB 2429 of 2022. It would have been para 2323. No, earlier also you had said this statement has been recorded. 4230. There's no, have you annexed the photograph also here?
Yes, yes.
Then I can give
Yes.
this.
Page 27, man.
Yes, please. Would let you.
As my learned friend has, my lord, submitted, my lord. There is the one side of, my lord, the third party's involvement is there, my lord.
Yes, yes.
So because of these reasons, my lord.
Yes,
to
yes.
find out, my lord, there is a lawlessness in the society, my lord. They
Yes,
are not
yes.
even, my lord, they
Very
are
difficult.
uniform people.
No, I have not mentioned, my lord. It is mentioned in the FIR.
Learned,
They are always free
Because
to
of that,
investigate that part.
Das,
my lord.
They are always free to investigate that part. That is their FIR.
submits that after he suffered a bullet injury, he was hospitalized, and his statement already recorded as as indicated above. It is submitted that he suffered a bullet injury on the backside of the house, and perhaps that would indicate that he was not charging at the base. That is your contention first. It is submitted that if investigation is sufficiently progressed, this subsequent bail petition may be accepted, and that he'll cooperate with the investigation. Full stop. The case diary was again called for and received. Full stop. the learned additional PP submits drawing attention to a note of the IO submits that the police had searched the petitioner in his house, but he could not be found. And stuff. However, there's not much investigation after the date of last rejection on 24/10/2025, and mostly it pertains to looking for the petitioner by the police. Full stop. Though investigation is not yet completed, but the CD indicates reasonably good progress. Full stop. Considering the progress of investigation, recording of the statement of the petitioner earlier, comma, the fact of his recovering from bullet injury, and the fact that there's no significant investigation after the date of last rejection. I'm of the considered view that perhaps allowing the subsequent petition may not prejudice the remaining investigation in any significant manner. Therefore, in such view of the matter, I accept this subsequent bail petition, and it is directed that event of his arrest, 40,000 with 1/0 of the like amount, to the satisfaction of the concerned learned arresting authority, and subject to the condition that he shall render cooperation to the remaining investigation. He shall not hamper or tamper with evidence. He shall not misuse his liberty to commit any illegal activities or offenses or any activities in breach of peace. Okay.
Well,
Kind of
highly
condition.
highly.
Should he record his statement or not necessary? Again, should he appear again?
If the lordship
Should he appear again?
He can appear, my lord. He is ready to.
My lord, if
Cooperate,
my lord
my lord.
required, my lord, he will cooperate with the investigation. My lord,
If required, he shall make himself available for examination again for that.
my lord.
Highly.
Just 2 minutes, I'll take a break. 42 minutes. 44. 44. 44. Just 2 minutes.
Did you have phone from my lord?
My lord, in item 44, my lord, we didn't receive the, my lord, CD, my lord.
My lord, Rangan Senior Counsel Mr. Ken Sudhi, he is appearing my lord in this case, my lord.
Okay.
Somebody
Marpit
left
case.
report is
Marpit
second
case
half.
again. Marpit case.
My lord.
Interim is there, my lord.
Diary is not received.
Diary knowledge.
She can take another date. Case diary is not received. Issue reminder. The interim bail granted by the order dated 18/11/25 stands extended till the next date of listing. It's on 21 or so. You're for the informant. Okay. Learned counsel, good name. M. Hussain appears for the informant. Will stop opposing the bail, right? You oppose the bail. When should we fix it? Three of you can tell me. Immediately after reopening.
Immediate reopening.
7, 8, 9.
7.
Or later.
After review vacation, my lord.
You want it? Any problem after BU vacation?
No, Lordship.
You want it earlier?
After winter vacation, Lordship.
No, not after BU.
No, Lordship.
Okay, before that.
7,
Lordship.
All.
Short 2 minutes. Yes.
My lord, in this case, case diary and postmortem report was called for in this case, your lord.
Okay.
Case diary received, my lord, postmortem report also received,
Mhm.
but my lord, final cause of death has not been ascertained, my lord, because FSL report of the Visara, one of that is pending.
I have not fully understood. What is the allegation actually? Would you like to read the FIR?
Yes.
Read the Ahom, yeah. Huh? That will be better. Page 15.
Yes, 15,
Yes, you can read it. We can read it together.
এজাহাৰকাৰীৰ গোচৰৰ বিৱৰণ এই যে যোৱা 15/10/2025 তাৰিখে এজাহাৰকাৰীৰ ভাতৃ শংকৰ মুদক ৰাতিপুৱা মোবাইল ফোন যোগে আছামীদৈ ফুৰিবলৈ যাম বুলি জনায় আৰু কিছু সময় পিছতে ৰাতিপুৱা 10:30 মান বজাত আছামীয়ে এজাহাৰকাৰীৰ ঘৰত উপস্থিত হৈ জোৰ জবৰদস্তি কৰি শংকৰ মুদক ফুৰাবলৈ লৈ যায়। উক্ত আছামীদৈ এজাহাৰকাৰীক টেলিফোন যোগে আছামীৰ হাতত ৰাখি থয়। টেলিফোনটো আছামীদ্বয়ৰ হাতত ৰাখি থয় আৰু তেতিয়া এজাহাৰকাৰীৰ ভাতৃ শংকৰ মুদৈৰ ল'ৰা ৰক্তিম মুদৈৰ বয়স 7 বছৰ টেলিফোন কৰি দেউতাকৰ ঘৰত আহিবলৈ কয়। তেতিয়া উক্ত আছামীদ্বয়ে তেওঁৰ খন্তেক পিছতে ঘৰত থৈ যাব বুলি জনায় আৰু দুপৰীয়া 2 মান বজাত এখন অলটো কলা ৰঙৰ গাড়ীত আছামীদ্বয়ে পৰিকল্পিতভাৱে হত্যা কৰাৰ কাৰণে এজাহাৰকাৰীৰ ভাতৃ শংকৰ মুদৈক লৈ গাড়ীৰ পৰা ইচ্ছাকৃতভাৱে ঠেলা মাৰি দিয়ে, যাৰ ফলত তেওঁ বাগৰি গৈ ৰাস্তাত লাগি থকা বোকাময় পুখুৰীত পৰি যায়। তাৰ পিছতে উক্ত আছামীদ্বয়ৰ ওপৰত উল্লেখিত গাড়ী লৈ তাৰ পৰা পলাই যায়। উক্ত ঘটনাটো এজাহাৰকাৰীৰ ভতিজা শংকৰ মুদৈৰ ল'ৰা ৰক্তিম মুদৈ আৰু এজাহাৰকাৰীৰ পুত্ৰ অবিনাশ মুদৈ আৰু ছোৱালী কস্তুৰী মুদৈ নিজ চকুৰে দেখা পাই ঘটনাস্থলীত দৌৰি আহি সহায়ৰ কাৰণে চিঞৰ বাখৰ কৰে। তেতিয়া ঘটনাস্থলীত উত্তম দাস আৰু ৰোহিণী দাসৰ ঘৰত কাম কৰি থকা শ্ৰমিক বিশ্ব দাস, তিলক দাস, ৰাজু দাস আৰু হেমেন মুদৈ উপস্থিত আছিল যদিও কোনো ধৰণৰ সহায় নকৰাকৈ তাৰ পৰা আঁতৰি যায়। তাৰ পিছত ঘটনাস্থলীত এজাহাৰকাৰীৰ শহুৰ কণ বৰুৱা আৰু ভূমি মুদৈ নামৰ সম্পৰ্কীয় আলহী এজনে আহি এজাহাৰকাৰীৰ ভাতৃক পুখুৰীৰ পৰা উঠাই লৈ বৰপেটাৰ ফখৰুদ্দিন আলী আহমেদ মেডিকেল কলেজ ও হস্পিটেলত লৈ যায় যদিও চিকিৎসকে চোৱা চিতা কৰি মৃত বুলি ঘোষণা কৰে। গতিকে
This is the allegation.
Your Honor, the accused person are not involved in this case, Your Honor, because he was in fully intoxicated condition, Your Honor. The disease.
That's why I refreshed because I don't. I'm seeing it for the first time. So this is the allegations. But in the backdrop of this, Dharmendra Muda and Jyotish Das are the petitioners, right? So what has the investigation revealed?
During investigation, my lord, the investigating officer has collected sufficient materials, my lord.
Against them?
Yes, there are also eyewitness, my lord. They took the victim, my lord, in their car, and while dropping them, my lord, the victim was pushed from the car, my lord. And my lord, he pushed towards the my lord, pond, my lord.
Mhm.
And there were
What kind of
eyewitnesses-
pond was that? Meteka?
So the Meteka or not, there it is stated as a pukuri, my lord.
But from where it is not easy to come out.
Yes, not easy to come out, my lord. And it was happened, my lord, in front of the, my lord. Eyewitnesses, my lord, those are, my lord, children, my lord. Not children, my lord, minor children, my lord. They are, my lord, teenage adults, my lord. So they are the eyewitnesses, my lord. They are still also recorded, my lord. They have implicated, my lord.
I do not know what in the
Can I have a look?
postmortem report, but he was fully intoxicated condition, Your Honor. And
Who, the victim?
The victim, Your Honor. And the pond was not so much deep, Your Honor. You can easily come out from the pond, Your Honor. In such a situation, I think the accused person are not involved in this case, Your Honor.
But, the eyewitnesses have stated about seeing them pushing the person
Pick the person from the vehicle, my lord.
from the vehicle
Vehicle, my lord.
where he fell into the pond.
Now pushing the person from the vehicle towards the pond, my lord. That is the matter. What about what is the eyewitnesses have stated?
Yeah. Right, right.
I have to take, my lord. There is no such injury in the body, my lord. For the postmortem report, my lord. So that is why, my lord, the Visara report, my lord.
Death by drowning.
That is not certain, my lord. In the final cause of death.
FSL report will take time. isn't it?
It might take time, my lord. We can fix it, my lord, otherwise, if lordship is one, those things that, my lord, that will be required, my lord.
It may be fixed, your honor, my lord, for Isara report, etc. Small, huh? Children is also custodian model. Third, Landed Council and petitioner and RJ Boda additional bid. Invoking 482, the two petitioners are seeking anticipatory bail in connection with Borpeta PS 365 of 25. It is submitted by the Learned Petitioner Council that the petitioners are not at all involved in causing the death of the victim, and that the incident might have taken place under might have taken place as the victim might have been totally intoxicated at the time. The case diary has been received. There is allegation in the FIR that the petitioners took the victim in a car, Alto car, and pushed him out of the car towards a pond, whereupon he fell into the pond, and by the time he was lifted, he had already died and stuff. In this regard, statements of some witnesses purportedly witnessed purportedly eyewitnesses have been recorded. Some of them are minors and teenagers also. Once a statement clearly indicates that the witness saw the petitioners bringing the victim in an Alto car and pushing him towards the pond, whereupon he fell into the pond, and thereafter the petitioners in that car drove away. The PM report is available, but final opinion regarding death has been kept pending receipt of the FSL report regarding Visser. In the circumstances, I do not consider it to be fit case for grant of interim anticipatory bail at this stage. Accordingly, the bail petition stands rejected. Return back the case. Deeply obliged.
46. May please go ahead. My statement was recorded, my lord, in 712.
Case diary not received, my lord. The date may be fixed.
Case diary is not received. Issue reminder. The interim bail granted to the petitioner by the order dated 2/12/2022-25 stands extended till the next date of listing.
21/1.
Public. 47.
47, my lord.
May please.
Charges submitted, my lord.
Serious injury, no?
No, madam.
And submitted persons have assaulted. The other persons have been granted anticipatory bail, right?
No, actually,
By the additional session judge,
no, my lord.
something like that.
Persons who were, my lord, against us, not those.
Yes, yes. The persons who had assaulted your
My lord.
families, according to your
Yes,
submission.
because there is a cross FIR from both sides.
So,
So they got bail, not in respect of case which was caused by our side, my lord. But we did not have been granted with the bail.
there's some, as per the FIR, serious injuries on the head.
Yes, we are also not the victim of the injury, my lord, because we have also submitted our the injury report.
But you don't have any other information, right? Apart from,
No, my lord, only one of the charge sheet has been submitted. my lord.
Therefore, my lord, that they have been granted with bail, my lord. So on the ground of parity, my lord, if the investigation is complete. my
last
lord.
order two. Okay, last order two. First three paragraphs same. That order is here, no? 1/12/2025.
My lord. By which the rival group was granted bail.
Actually, my lord, Lordship Perus page number 39, my lord.
39.
Paragraph number 6, my lord.
Hmm. Hmm.
We have admitted, my lord, because
Hmm.
we are also subject to injury, my lord.
Hmm.
And that would, your lordship will
Hmm.
find at page number 30.
Yes, yes.
That we got admitted at GMCS on 30th
Yes, yes.
of October and discharged on 13/11, my lord.
It is submitted by the petitioner counsel that a cross case. Do you have the case number?
Yes, my lord.
Nagarbeda PS 74.
75 is the, my lord, the case lodged by us, my lord. And in
seven-
respect of 74, we are seeking bail, my lord.
Yes. Nagarbeda PS case number 75 of 25.
My lord.
Within bracket. Cross case is pending. And in that case, the accused persons therein have been granted bail.
My lord.
It is submitted that members of the petitioner side have also sustained injuries for which they have undergone hospitalization. The learned additional PP submits that in the meantime, investigation is completed in the instant case and resulting in a charge sheet. So, what about the other case? It is also under investigation or charge sheet?
That we are
Not sure. That you cannot. Well, dispose it of it.
CS number 277/2025, dated 15/12/2025,
Recently, it was filed.
recently.
In view of completion of investigation, perhaps despite the serious nature, despite the seriousness of the allegations, not much purpose might be served by detaining the accused persons at this case, and hence granting of anticipatory bail to the petitioners at this stage may not be prejudicial to the prosecution per se. In such view of the matter, it's directed. How many petitioners here?
2 petitioners.
30,000 each.
My lord.
The subject arresting authority, subject to the condition, they'll be available for trial. And if one commences, shall not hamper or temporary dividends, shall not misuse their liberty to commit any offences, illegal activities, or any activities in breach of peace. Violation will entail the bail petition stands allowed and disposed of.
I'm obliged. Supplementary 56.
I'm on interim protection, lordship. The updated PCI was called for, as charge sheet has been laid.
Charge sheet. Yes, yes.
PCR has not received, my lord.
And somebody has appeared for the informant.
No, lordship, the informant is a police person.
Achha.
Rafiq, I have a certified copy of the charge sheet. My name is not there.
It's not there, not sent up for trial.
I am Sivo Prasad Kumar. My name is not there in the first of lordship.
Siva Prasad Kumar.
Yes, sir.
No. Immoral preference. So we dispose it of.
No, my lord, if his name is not there, my lord.
Yeah.
So question of my lord, apprehension of marriage does not arise.
True. That is true, but
Yes.
interim is there, so it has to be, cannot be vacated also. No? So it has to be.
Let the bail application be closed, my lord. Otherwise, my lord, granting him interim protection does not,
Makes no sense.
you know,
Of course,
it does not arise at all, my lord.
I'll think about it, but something has to be, the
Let this-
interim has to be taken to some logical conclusion.
Some logical ground, my lord. Since there is no apprehension, my lord. Search sheet has been, his name is not in the search sheet, my lord.
If
So-
we close it, then what will happen to the interim? I'm just trying to learn from you. If we close it, suppose.
Lordship mentioned that, my lord, since in this case, the search sheet has been submitted, my lord, and petitioner name has not been mentioned, cited as an accused in the search sheet, my lord. So, my lord, this bail application is
Not maintainable.
Not maintainable disposal. This is my
No, I think you have a point actually. FR is there's nothing. There's nothing that means the cases goes against you. So I'm gonna go to Tasselita. It's 3 paragraphs in. Four listen. The informant, a police officer, is being represented by the learned additional people. So, the petitioner was granted interim bail on 23/10/2025. It is submitted by the learned petitioner counsel that in the meantime, the case has been charge sheeted. And in support of his contention, he has submitted before the court, is placed before the court, a certified copy of the charge sheet being CS number 273 of 2025, dated 10/11/2025. It is submitted by the learned petitioner counsel that the charge, after investigation, the present petitioner has not been sent up for trial. Upon perusing the charge sheet, I find that the same has been filed against 1, 2, 3. 3 accused persons, which does not include just a minute. Actually, last one. Upon perusing the charge sheet, upon perusing the charge sheet, I find that the petitioner is not one of the listed accused sent up for trial. Now, what to do? So I have made absolute in earlier occasions also. The learned additional PP submits that in view of this development, the apprehension of arrest of the petitioner becomes baseless. At the same time, I find that as the petitioner was granted interim bail, and therefore the said order also has to be taken to its logical conclusion. Therefore, though I find force in the contention of the prosecution that the apprehension of the petitioner's apprehension of arrest has lost its basis. Nevertheless, the interim bail granted by order dated so and so is hereby made absolute, subject to the condition that he shall cooperate with the process of law. That's all. But you find out, this thing. I'm not fully sure whether this is the way it should be done. We find out, we learn, I learn. Take it back.
Deeply obliged, Lordship. Lordship, may I take back the charge sheet?
Yes, yes, it's for you. You'll need its original copy. Disposed of. It's actually no video. This judgment is yours. Oh, it's mine. Anyways.
$58.
This matter came to lordship yesterday also, madam. Yesterday it came before lordship matter. They find an objection. They will come. We also had my reply also, madam.
What's this one?
This is also in the file.
You filed a reply also.
Now, my the whole case is based on my family matters, madam. They are civil suit. My materials also maybe there because both the parties are ran for a long time, my lord. We have filed 107 case also against them. And the relation is my informant is the cousin of the accused number 1 and 2. Own cousin, my lord.
Yeah, it happens within family.
So ultimately, my lord, what I find, my lord, subject to what your lordship say, or my lord, friends say, my lord. But ultimately, I find, my lord, it is not a case for custodial interrogation, my lord. Disputed regarding land, my lord, extortion, they have cited that I have also made some extortion of 50,000. Then, so ultimately 7 years. So actually, my Ernest Kumar comes also, my lord. That we also, my lord. Yes, what I did to your lordship, my lord. In my humble submission, it is not a case for custodial interrogation. They have submitted my yesterday some objection. In the case they have stated that I have been put under suspension from Gaubura. There is another aspect that I am going to challenge also, my lord.
Okay, anyway.
Yeah, so that is another aspect, but I may do some other offenses, my lord. But at
1311 is the Azahar, right?
Yes, my lord.
1311. I'll quickly go through it once.
English version.
I'll quickly go through it once.
My lord.
Brokers of land taken.
Own cousin. That Khali killed.
Okay, many allegations.
My lord, 18, page 18, your lordship will find Jainab Bibi, page 18, the mother of the informant. That is sister of my father, my land transfer. It was agreement,
Sister of
nothing.
the Joina Bibi is sister of your father.
My lord.
Pehi.
Sister, yeah, Pehi, my Pehi. So ultimately, my lord, and your lordship knows when the some dispute among the relatives, sometimes they get higher degree, my lord, sometimes. Just like husband and wife, my lord. And your lordship, so many papers I have given, and they have submitted, my lord, yesterday, your lordship will find, they have submitted some documents which show that, my lord, I have been expelled, suspended from the post of Gaubura. That another aspect, my lord, that was not served me idea. Now I came to know, and we are going to challenge, my lord, that part, my lord. And other things, they have given some resolution of the Idga committee. Whole one Idga committee was there, my lord. Two groups are there. One group with the informant side, another group with the both sides by resolution. They have also submitted, we have also submitted the resolution. At this stage, matter disputed fact, in my humble submission, I think your lordship may consider subject to what my learned friends have. And 126 pending matter. We have filed 126 page 85. That is also pending. 107. Idea 107. I think some elderly people will come up, my lord, to settle up the matter. I think, my lord.
They should
That showed my lord also, my lord. All
Well,
regulation, my lord.
anyway, there's some allegations anyway.
Yes, extortion. Yes, only extortion, my lord, other than nothing.
Yes, that allegation is there.
Yeah, only that.
Within the family. Anyway, so.
And I just, my lord, out of the, my lord, dispute, my lord, wherein, my lord, this accused petitioner, he is the Gaon Bura, my lord.
He's a accused number one.
Accused petitioner,
Like one
petitioner, my lord.
Petitioner
Gaon
hearing.
Bura, my lord, yes, village Gaon Bura. So, my lord, the informant, my lord, he has applied for some certificate to, my lord, partition his land, my lord. Then, my lord, what happened, my lord, as per their allegation, my lord, they filed an application before the circle officer, my lord, with an objection, my lord. And to withdraw this objection, my lord, it was alleged that, my lord, the Gaon Bura has demanded 2 lakh rupees, my lord. And out of which, my lord, they have already paid 30,000 and it's 50,000 rupees in cash, my lord. This is the allegation, my lord.
And the Gaubura is a relative of the informant.
Same.
My learned friend is submitted, my lord. I do not know that.
My lord, no, Gaon Bura is the present petitioner. my lord.
Yes, I get it.
Yes, ma'am.
Get it. Okay.
But it arises from a, my lord, partition case, my lord.
Partition.
That for which, my lord, the his Gaon Bura certificate is required, my lord. And when they came to, my lord,
I want to say, mother document, otherwise custody interdiction may not be, my lord.
Anyway. Mr. Agarwal,
and
some-
regarding, my lord, the payment, my lord, there in the case diary, my lord, there is two, my lord, screenshot of the, my lord, payment, the 30,000 rupees, my lord. But that I have to point out, my lord, that
that is
was
the only problematic.
yes, it was
aspect.
a page to, my lord,
Otherwise it's,
Buttu Durgapur, my lord. Now, who is Buttu Durgapur, my lord? Would not know, my lord. Buttu B Durgapur, my lord. Whether, my lord, this is the account number of the, my lord, this present petitioner or not, my lord, it is not clear from the case diary.
If I may assist your lordship.
I'll just come to you. Okay, please.
Yes, the accused petitioner does, he's a Gaon boya, he's a very influential post. So what he does is that if there are local villagers who are, they want to sell any land, they have to obtain NOC from the DC, district office. So what this Gaon boya does is that he says that he goes and files a fake complaint before files an objection. And in lieu of that, he asks for money. It's not that he has only filed for, only in my case. It's true that I happen to be his relative, which is, but he has been doing, it is his modus operandi. Well, let's kindly come to his affidavit in opposition merits. At page 53, my affidavit in opposition merits. At page 53, there is no reasoning and what is his ground for filing an objection. Now, your lordship, pursuant to this.
Sorry, can I have a look at your objection? You filed objection. It's this one, no? Must be.
Page 53.
Oh, page 53.
Page 53.
Annexure 1.
Annexure 1. There is nothing on it. It's complete blank as to why he is giving an objection. There has to some locus, there is some explanation. Now your lordship come to next page. Now your lordship will come to the page 16.
Yes.
Page 60 minutes.
60.
Yes, sir.
Yes, I'm on 60.
Come to the second page. There is a reign of terror of his in the entire village. That is why 152 people file a complaint to the DC, and DC takes in cognizance. DC initiates an inquiry, and then DC decides to terminate him. Kindly come to second page. The complainant alleged that Sri Sohiddin Uddin so and so had initiated an illegal extortion racket targeting the common citizens of Singaripar revenue village, and that he had been extorting money by creating virus
issues such as land grabbing, manipulation of land records, and unauthorized dealing of government land. In the view of the findings of the inquiry of the allegations, the undersigned is pleased to place the service of the Gaon under suspension. Now, minus the DC has done an individual inquiry, then he comes on gives a finding that here is a person who is being who is terrorizing the entire village. So, then page 61, I have the sample complaints, the other people who have filed complaint. Now, one of the things that it has been alleged, what their claim is that this is a civil dispute. My contention is that all of this is an afterthought only to get, or in the garb of which they want to get a bail. Because they have not preferred a civil suit. And their entire story that they have preferred a 126 BNSS, 107 CRPC, they have preferred after I filed an FIR. In that story and the allegation that they have written in their main bail petition is entirely contradictory. In the bail petition, they say that my mother got land from his father. And in the 107 CRPC, the complaint, it's entirely different. In the contrary, what has happened is that my mother inherited land from her ancestors, my lords. Now they are objecting to it. And it is not only with respect to it is with respect to the entire village. And also, my lords, they have accepted it, that they have taken money from in their own bail petition, para number 4. They have also accepted that they have taken money, rupees 30,000 from Dr. Nadeem. Now, my lords, with respect to that, the IDGA committee at page 54, in my affidavit in opposition, they have affidavit in opposition. The IDGA committee has passed a resolution saying that no money has been received, and this person, the accused person, is using the challans of the IDGA committee and transferring the money in his own name. Page 54, my lords, kindly come. So, my lords, in this respect, my lords, I don't think so, my lords, it's a fit case for granting bail, my lords, because custodial intention is also be necessary because there are certain land documents. The DC specifically mentions this examination order that he is also involved in manipulating land documents. All of these documents will be with him. How will he produce before the trial? Will the police? No, he won't. So, my lords, at this case, and my last submission is respect to Ernest Kumar, my lords. Now, Ernest Kumar, it is not that once the Ernest Kumar is pleaded, the anticipatory bail has to be granted. There is a checklist. So let the investigation make that decision whether it's a fit case to that 41A notice should be given, or whether it's a fit case where checklist should be given and he should be arrested. Let the learned trial magistrate court make an independent view. So that will be my humble submission.
Yeah, good. I think yes, sir. You can make it. I'll look into it.
I live to watch. My only thing is about whatever he's saying, hundreds of offenses I have committed, my lord. Whether I am, my lord, here, your lordship is to see this case, my lord. IDGA committee is not coming. They have suspended me. IDGA committee, 2 groups, my lord. Page 92, your lordship will find our reply to his, that's my lord, representation. We have also given reply. 2 groups, as I said earlier, my lord. Out of 2, 1 group, my lord, father of the informant is the, my lord, president of the IDGA committee. Informant himself is the secretary. So that's why, my lord, I think it is all, everything is a documentary and it is a dispute and that way of life, my lord. I think custodial interrogation, my lord, everything, let him appear, he will cooperate, whatever condition also imposed, my lord, he is ready to do, my lord. The rest I leave to your lordship, my lord.
I think to continue the word. I'll give me the case that I'll dictate now because we'll have to fill the mentions now. I think remaining matters. I'll dispose it today. I'll dispose.
Only one aspect, it shouldn't impinge the investigation that is going on.
Yes.
Police 41A notice, Ernest Kumar is not a blanket.
It's my duty to see that.
You may appear, my lord, only interim bail may be granted. That's no problem, my lord. You are the government responsible. Anyway, our reply is there also.
I'll see. That's why I'm taking some time.
Then I lift you
not there. Yes.
Allah to
yes.
Well done.
Chamber. Let us go for the mentions.
I have item number 8.
Yes, yes.
Okay.
That's why. Let us, I'll be here, don't worry.
This is-
I'll not rise, take all the mentions and then I'll rise.
This is the
Item number
loaded-
6 was,
8.
just a minute, 6.
Item
Six,
number-
sir, 6. Where was it? Oh, just a minute. Report was called for in this case. None has appeared actually. Mr. Yeah, Som, Mr. Sur.
If Madam, we have not received the report, Madam.
None appears today to item 6. AB 562, none appears. Stop. The learned additional PPRJ Bora submits that the report as called for has also not been received. It's pending for a long time, March.
Well, the petitioner is also not appearing.
Yes, yes.
So why, Madam, why is the
Disposed
user,
of.
Madam, keep this?
They can
application
file
pending?
again, file it again.
If the petitioner is not, Madam, present
Yes.
in that court. Madam.
Last date he has not appeared. Last date he has not appeared. What should we? Close?
Lordship has called the matter twice, Madam, in the morning itself and now also.
So, none appears today on second call as well. Also. Report is not received. So the matter has been pending since March. I find force in the contention of the learned additional PP that the matter can be closed at districts according the bail petition. Is dismissed on default. I'll dismiss on default.
Yes, sir.
Dismiss on for default. They can file again. There's
Yes, they
some
can
cause
file
of action. Dismiss for default and disposed of accordingly. Yes, now. Criminal petition 8.
Lordship,
Right?
item number 8.
Yes.
I am for the petitioner, the
Yes.
respondent.
As legal aid counsel, right?
Yes, Lordship.
The maintenance matter.
Maintenance matter, Lordship, and
Yes.
the challenge has been made to an order passed in 2023 and the revisional court had passed the order in May 2024. The petitioner, being the wife of the respondent, is not receiving any maintenance and her 2 minor daughters are
Complete
getting.
stay. The impugned order is under stay.
No, Lordship.
Not stay,
No, Lordship.
but he has not paid.
Lordship, the minor daughters are getting only 3,000 per head. And that does not even cover their educational expenses.
Generally speaking,
And-
no, certainly no.
In this case, the main contention is the guidelines laid down by the Honorable Supreme Court in Rajneesh versus Neha were not followed by the trial court nor by the revisional court.
Achha. Regarding
The
affidavit.
assets and liabilities, the affidavit of assets and liabilities was never called for. It has not been filed. And the salary of the respondent herein is approximately 48,500.
Okay. How come none has appeared? None has appeared.
None has appeared for the respondent, Lordship.
What can we do today? But ever filed with us. It's 2 weeks.
On the last date also, Lordship, due to paucity of time,
Yes,
this
yes,
could not be taken up.
Everything is not getting covered. Bail, admission, orders.
Yes,
It's not
Lord.
getting covered. I have a plan if I'm on the, whenever I'm on the roster again, take orders at 4. So that at least we touch it every day. But if no, it has been narrated also. Who, since you are appearing as legal aid counsel, how the steps are being taken through registry?
Yes, Lordship.
Through registry.
Yes, Lordship.
That service report is also not there.
Lordship, there was an office note, as far as I remember. I had mentioned on the last day that there is an
Has
office
been
note.
received by recommendation. As per a report notice. Pankaj Borua, brother of the respondent.
Lordship.
He has received.
Yes, Lordship.
Pankaj Borua, Tarun Borua's brother.
Yes,
So
Lordship.
that will that do?
Yes, Lordship.
Staying in the same house.
Yes, Lordship. There was just one address that we had given.
This is the last office note. P. Agrawal, learned counsel, appears as legal aid counsel for the petitioner. Full stop. As per office note dated 1/11/2025, service report upon the sole respondent received with the report that it was delivered to the brother of the respondent at the stated address. Flag A to X, flag X. High Court decision. Sir, for the total. So we can take it as complete.
Yes, Lordship, it is complete.
As the notice was sent to the address in the cost title
Yes.
and received the respondent's brother staying in the same premises. Therefore, service upon the respondent is taken as complete. We'll stop. So record we have received.
Lordship, in fact, I have annexed all the documents
Yes.
which were there.
We did not call for the record. I think we must have.
Lordship, only
Notice,
this-
oh, I think it was not, should have called it last week. Any case, we have today, it will be after vacation,
Okay.
right? In the meantime, let's take advantage of this, we'll take this. Issue requisition for the scanned case record of miss case number 03 of 2022 from the court of the learned GMFC, Bongaigaon. Full stop. When should I fix it? After,
Lordship, as soon as possible. It depends on the record also being available.
let us fix it after vacation, first week before Bihu.
Lord-
And we'll take it up on at 2 p.m.
Lordship.
Since it's a maintenance.
Yes, Lordship.
matter, we'll take it up. List the matter on
Could be on 6th or 8th.
six on 6/1/2025. It's 26. Full stop as the at 2 p.m. At 2 p.m. Considering that it's a matter pertaining to maintenance in which the petitioner is appearing through a legal aid counsel.
She has 2 minor daughters.
Petitioner with 2 minor daughters appearing. There has to be a reason for everything, right?
Lordship.
In this world.
Yes, Lordship.
So
Obliged, Lordship.
2 o'clock.
For orders. Item 9, it is serial. My lord, item 9.
Yes.
I have filed criminal for quashing criminal proceeding, my lord, child marriage. My lord already.
Take a
passed.
date, no?
My
Take a
lord,
date.
can dispose of.
No, no, not only because it's risky, because something might, we should
Already
not
my
go
lord,
superficially. At least see it. If you get a date list after vacation, he'll give you that
On
date.
8, my lord.
He'll give you that date. huh?
8/1. And my lord, there is interim, my lord, that may be continued.
Interims, all interims will be continued. Don't worry, that is automatic. That's not your fault. It's not reached. 8 or after view. Why not after view? Will you face any prejudice?
20.
Well, I'll leave it to him. He'll
20
give,
or
he'll give you a date. I'll not interfere. Yes, Mr. Jalan.
Item number 10, my lord, there is a interim, the
Yes.
further proceeding has been kept in abeyance till the returnable date. That
Yes.
may be extended till the next date of.
That's not a
listing.
problem.
And my lord, item number 11 is also connected in the way that the matter relates to that. There is a
10, 11.
identical allegation. 2 offense report has been filed by 2 forest
You're
officials.
seeking caution?
Yes, my lord. The item number 11 is a fresh matter, my lord. That was heard little and it was fixed. And on my pointing out that another offense report has been filed, so both the matters has been
Tagged
came up
together.
together.
Not
So
tagged, they are together.
they are together. So
Okay,
I-
you take a date as per your
can it be on
convenience.
7th, my lord?
Then
That is a fresh matter, item 11.
Because see, the things, the many matters have been fixed already. Unless there is some urgency, you can take a little space.
Then after view
After
vacation,
view-
it can be
view-
taken, because
view.
to my instruction, lower court's date is on 2nd of February. So 21st, can it be on 21st of
I'll
January?
leave it to him. He'll give you the date.
Both the matters may be come
Take it,
together.
take it.
Of much obliged.
Yes, this is admission. Only 4 addition, right? Then we come to orders.
Admission first.
Orders. There were a lot of orders today, but we could not fix 50 for 40. Take a date, you know.
So for orders,
Your matter is?
49 to 52, and the supply matters from 65 onwards. 61 to 64. These are tagged matters. 49 to 52 in the daily list, and 61 to 64 with supplementary list. I filed the IA actually, and it was tagged, so that has come up in this.
So all these 61 to 64 will come together.
It will come
together. Paucity of time after vacation. Interim order declare automatically.
Lordship,
based on-
it's in regard to
It
49 and 50, there is an interim in that.
No, you're 49 also.
49 to 52.
Yes.
Oh, I see. So these are also.
So therefore, because
see.
the trial court cases are going on, as such, these are summary procedure. I seek a date as early as possible.
Means that it's not anyway. So. So they have to come together. All-
Yes, Your Lordship. I'm appearing for the petitioner side, Your Lordship, in item.
Take a common
49 and
date,
50,
then
there is an
give a
interim.
date. I think realistic will be after Bihu.
A realistic date.
No.
That's
Because these 2 days will not be possible. Immediately after reopening, we can fix, but again, you know, many matters will come.
Yes, Your Lordship.
So if you insist, then I can fix it.
if I do insist that it may be fixed before Bihu. I have some personal constraint after Bihu as well.
Lordship, can it be after Bihu vacation?
No, I have some personal constraint. Our senior knows about that too.
9, sorry,
Nine?
last day.
Last-
Friday?
Yes, Friday night.
But I don't know again whether because reaching is a big problem. We can fix it on 9. 9. 9. No, it'll come. It'll
It'll
come.
come.
It will be listed.
Much.
Oblige, Your Lordship.
My lord, I am for item number 53, Lord.
Just a minute. That's okay. So you're for 53.
53. I have for the condonation of delay of 11 days, Lordship.
Acha.
Learned fact.
I'm already appearing for the sole respondent. Lordship.
Okay. You have no objection?
rational more to Lordship.
You have
I
objection?
have no objection.
No
on
objection.
dealing- Condemnation of delay of 11 days. Lordship.
Then we'll do that. We'll condone the delay
Lord.
and admit the appeal.
Lord.
Right? Is it POXO or something like that?
POXO.
POXO. So notice you take fresh notice or you'll accept.
Already I accept. my lord.
You can accept. Good name. Your good name, please.
Our hope. Lordship.
Arho.
I already filed Wakalotnama by today.
Okay, no problem. So 53, delay condoned, appeal admitted. I'll elaborate. We'll declare.
Date may be fixed.
Let it be in first week of February.
He is behind the work.
Yes.
Since
The thing is that
2024.
all records will come, then notice, everything will come. At least last week of January. 29/1. 29/1. Okay. Then 54 and 48 are there.
54 I am.
Lord, I'm for 48, my lord.
Uh-huh.
But maybe listed after Bihu vacation.
After vacation.
After Bihu vacation.
After, yes. Fix in the last week of
Service
January.
awaited otherwise. Respondent.
Service is awaited. Paucity of time, list after VU vacation on a date to be fixed by registry. Some dates we should leave to them also. They can fix harmoniously. 48, anybody?
I am for 54.
I'm for 48.
Oh, you're for,
I'm
sorry.
for 48.
48 to 82, huh? After to be date fixed by registry.
In 54, Your Lordship, telco record a receipt, but regarding service is not only. I am place for matter be listed before the Lozama court regarding service. They will decide whether
Should I?
because service is not returned.
The learned counsel praised for listing the matter before Lawazima court with regard to service, which is stated to be not yet completed. First, prayer is a list before Lawazima court. Then it will come back again. Anything else?
Your Lordship, just to be on the safe side, that item 49 and 50, the interim is there, so.
Interim will continue.
Continue.
Yes,
Okay.
don't worry, don't worry. So take leave. এইটো এইটো মই স্পেলটো নোট বনাইছোঁ দি দিব কথা বিচাৰিছোঁ